The Senate will come to order. Senator Murphy.
Mr. President, I impose a call of the Senate.
The Senate is now under call. Senator Murphy.
Thank you, Mr. President. I move that further proceedings under the roll call be dispensed with and that the Sergeant at Arms be instructed to bring in the absent members.
Members, on that motion, all in favor say aye. All those opposed say no. The motion prevails. Members, in our tradition, we always start with prayer. And today's chaplain is Sharon Day from the Indigenous Peoples Task Force in Minneapolis. And following the prayer, please remain standing for the Pledge of Allegiance.
Bujun and Indue Maganidug, Nagamo Ma Ingan and Dishnakaz. In Ojibwe, I said, greetings, my relatives. And when we say Ninindue Maganidug, we are speaking to not just the humans in the room, but to all the plants, the animals, the fish, and the earth, the air we breathe. And in my spiritual path, we have 7 sacred laws, and that we are given instructions to follow. And I know that in every spiritual pathway, there are similar values. And in ours, it's to be loving, to be kind, to be honest, to be humble, to be courageous, to take a stand, even if you're the only one standing, to be respectful, and to be humble, knowing that no one is above you and no one is below you. And also to seek wisdom and to be generous. And if we were to follow those 7 teachings that are in all of our spiritual pathways, we would find peace. We would find harmony between all living beings around the world. So I offer that to you today. And in our spiritual path, our teachers always say, all of the stories of the spiritual paths around the world are true. They are all true. We only know our path. So I'm just going to end with a song that calls all the 4 directions, says thank you to the earth, to the sky, and to all of our ancestors, and especially to that most kind creator, Gajay Manadu. Wabanang shawanang ingabia kiwadanang. Wabanang shawanang ingabia kiwadanang. Miigwech wendan ni mama ki. Miigwech wendan ishpaming. Miigwech wendan bimadazi wen. Miigwech wendan no komisanan. Miigwech wendan mishomisanan. Miigwech wendan gijimanidu. Miigwech wendan no komisanan. Miigwech wendan mishomisanan. Miigwech wendan gijimanidu. Ajuena Mishanan, Gijemanidu, Ajuena Mishanan, Gijemanidu, Ajuena Mishanan, Gijemanidu, Ajuena Mishanan, Gijemanidu, Nikan, Nikan, Nikanikana, Miigwech.
Thank you, members. The secretary will take the roll.
Abler, Barr, Bolden, Carlson, Champion, Clark, Coleman, Swadzinski, Dames, Dibble, Dornick, Draheim, Drazkowski, Duckworth, Farnsworth, Fateh, Frentz, Green, Grunhagen, Gustafson, Hochschild, Herr, Heinzmann, Hemmingson Jaeger, Hoffman, Holmstrom, Housley, Howe, Jasinski, Johnson, Johnson-Stewart, Klein, Coran, Kroon, Kunish, Kupek, Lang, Latz, Liskey, Limmer, Lucero, Mann, Marty, Matthews, McQuaid, McEwen, Miller, Mohammed, Murphy, Nelson, Verbaten, Pappas, Pa, Port, Pratt, Putnam, Rarick, Rasmussen, Rest, Seeberger, Utke, Weber, Wiesenberg, Westlin, Westrom, Wickland, Zhang.
Members, a quorum is present. The following members intend to vote from a remote location under Rule 40.7. Senators Carlson and Port. Members, if you want to follow along, I'm reading from today's Senate agenda dated Wednesday, May 6, 2026. We will begin at the third order of business, which is messages from the House. The Secretary will read the message.
Mr. President, I have the honor to announce that the House has acceded to the request of the Senate for the appointment of a conference committee consisting of 4 members of the House on the amendments adopted by the House to the following Senate file. Senate File Number 4760, a bill for an act relating to public safety. There has been appointed as such committee on part of the House Novotny, Whitty, Mueller, and Feist. Senate File Number 4760 is herewith returned to the Senate. Signed, Patrick Duffy Murphy, Chief Clerk, House of Representatives.
Members, no action is required. We'll now move to the fifth order of business, reports of committees. I'll call now on Senator Murphy for a motion to adopt the committee report. Senator Murphy.
Mr. President, I move the committee reports printed in the agenda be adopted.
On the adoption of the committee reports, all in favor say aye. All those opposed say no. The motion prevails. Members, will now move to the seventh order of business, which is second reading of House bills. The Secretary will read the House file numbers.
House File Numbers 1141, 3521, 3522, and 3900.
The House files have been given their second reading. Moving to the eighth order of business, which is introduction and first reading of Senate bills. The bills listed on today's introduction calendar are given their first reading and referred as indicated with no modifications. Moving to the ninth order of business, motions and resolutions. Members, we will adopt the author's motion as one motion. All in favor say aye. Those opposed say no. The motion prevails. Senator Murphy for a motion.
Mr. President, I move to take House File Number 1082 from the table and given a second reading.
To that motion, all in favor say aye. All those opposed say no. The motion prevails. The Secretary will give House File Number 1082 its second reading.
House File Number 1082.
Senator Murphy.
Mr. President, I move to lay House File Number 1082 on the table.
To that motion, all in favor say aye. All those opposed say no. The motion prevails. I'll again call on Senator Murphy for a motion to take Senate File Number 1750 off the table.
Thank you, Mr. President. I move to take Senate File Number 1750 from the table.
On that motion, all in favor say aye. All those opposed say no. The motion prevails. I'll now recognize Senator Lucero.
Thank you, Mr. President. I'd like to renew my motion that the Senate concur with the amendments by the House to Senate File 1750 and that the bill be placed on its repassage as amended.
Senator Lucero moved that the Senate concur in the amendments by the House to Senate File Number 1750 and that the bill should be placed on its repassage as amended. Senator Lucero, now give us a sense of the differences between the House and Senate file first. Senator Lucero.
Thank you, Mr. President. I'd also like to ask for a roll call on the motion to concur.
Roll call requested, roll call granted. Senator Lucero.
Thank you, Mr. President. And before I go through some of the highlights of the changes, I want to express a few words. It was exactly 1 year ago today, 1 year ago on this very date, that we passed Senate File 1750 off of this body. As part of the process leading up to passage a year ago, and then in the year since passage from the Senate, this has been one of the most collaborative, fun, rewarding, and beneficial efforts I've ever engaged in my 12 years in the legislature. Senator Pa, Representative Bonner, and Representative McEwen have been an amazing team. We have met dozens upon dozens of times, which amount to hundreds of hours. We've met on weekends. We have met in person. We have collaborated through a number of work groups, through a number of listening sessions, through many, many evening Zoom sessions, which went 2+ hours. This entire effort has been amazing, and I'm very appreciative of my co-authors and counterparts in the Senate. The HOA Bill of Rights, which is 1750, it is achieving transparency, best practices, and it is a consumer protection bill. Some of the changes, now we've had this bill on the table, we laid it on the table on Monday, so we've had 48 hours. I'm not going to go through every change, just a few of the highlights, but what I will say is that the changes that have happened in the House have been moving in the direction of compromises by those in the other stakeholders. It looks like you were going to say something, Mr. President.
Yeah, Senator Lucero, just remember that where we are in the process is just to talk about the changes between the House and Senate, because then we have to adopt your motion, and then you have a chance to talk about the rest of the bill before we give the bill its third reading.
With that, Mr. President, thank you. A handful of the changes. When it left this body, there was a vote to dissolve an HOA of 60% needed. The change is now 67%, so that was increased in terms of the percentage of unit owners that were needed to dissolve. There is a provision to limit late fees. When it left this body, it was $15 or 5% of the amount owed. That was increased to $20 or 5% of the amount owed. The interest was limited, and it was, and when it left the Senate, interest was prohibited, and now coming back, interest is limited to 8% on unpaid common expenses and special assessments. HOAs must provide information about fines to existing and new homeowners. When it left the Senate, it was a schedule of fines. Coming back, it is a list of common fines. Homeowners may have assistance of an attorney or a designated representative. When it left the Senate, the homeowner had the opportunity to be represented by an attorney. Now they have the opportunity to be advised by an attorney. Fees are limited for documents needed for the resale of a unit. When a property that is in a CIC is listed for sale, there's a number of documents that need to be given to the potential buyer. The price for that is borne then by the seller. When it left the Senate, it was a limit of $150 could be charged, and when it came back, due to changes in the House, it is now at cost. So whatever the cost is to the HOA, that is what can be charged for those documents. Terms cannot exceed 3 years for board members. And when it came back from the House, now terms must be staggered that are, unless the terms are less than a year. Bids are required for contracts exceeding $50,000. The House adds an exception if the cost of materials is not more than $50,000 and labor is done by volunteers. Retaliation was prohibited when it left the Senate, and the House simply put a definition to retaliation. Governing documents and property manager were referenced in the bill when it left the Senate, and governing documents and property manager are now defined when it came back from the House. There was no limit to how many terms a director could serve on the board, and that was a recommendation, a provision that was added that there was no limit to how many terms a director can serve as it came back from the House. And then lastly, one of the other highlights of the changes was a provision regarding safe at home. A violation of the existing safe at home law, which is Chapter 5B, unauthorized disclosure of a victim of domestic violence participant in the safe at home program is now a violation of Chapter 515B. This was, again, a change from the House. Those are some of the highlights, Mr. President, and again, I encourage a green vote on the motion to concur.
We're on the motion to concur. Senator Latz.
Mr. President, will Senator Lucero yield to some questions?
Senator Lucero, will you yield? He will yield. Senator Latz.
Thank you, Mr. President. And Senator Lucero, thank you for all the work that you've done to try to protect homeowners in HOAs. We all have our own experiences that we can identify either our own or from our constituents where we've had difficulties with HOAs. And I generally support the direction the bill is going, but I'm very concerned about concurring with all of the House amendments without having some further analysis through a conference committee. So I'm seeking some clarification on some of those changes. Senator Lucero, if I could ask you to turn to page 15 of the third unofficial engrossment. This has to do with board meetings and approvals of fines over $100. I have a question for you when you are ready at that location.
Senator Lucero, do you have the location? He has the location, Senator Latz.
Thank you, Mr. President. Senator Lucero, on line 6, it says at a board meeting, and then line 7 refers to at which a majority of the votes in the association are allocated, approved by owners of units to which a majority of votes are allocated. It implies at least that any board meeting would be covered there, where, as I understand it, only board meetings that are especially called special meetings for which appropriate notice is given, or the annual meeting, are ones at which members are allowed to vote. Is that your understanding, or do you think I'm misreading that language?
Senator Lucero, to the question.
Thank you, Mr. President. And here's some clarification on that. The clause allowing homeowners to vote to increase the maximum fine amount for a minor violation was provided as part of an extensive input from the chair of the Minnesota Common Interest Ownership Subcommittee of the Real Property section of the Minnesota Bar Association, essentially as expert in CIC law, Tom Bray. The Chapter 515 provides for homeowner voting at meetings in contrast to the statement above, referencing that this would be a potential problem. And so existing law is that the association may obtain the required approval by a vote of an annual or a special meeting of the members. So this is something that's already in law, existing law, and this provision is something that's not entirely new of members voting at board meetings.
Senator Latz.
Mr. President, my understanding is that, first of all, Mr. Bray, and we thank him for his service in the Bar Association, but he does not advise boards of HOAs. So I query whether or not the language is the best language that we could have. It doesn't even indicate whether or not, if it just says at which owners are eligible to vote. I think that clarification would be helpful. And the input I've received from some of the stakeholders here is that the language as written would actually create a legal nullity at a board meeting, because with 50% of all unit owners in attendance, it wouldn't work the way it's written. So I respectfully suggest there's some clarification that might be in order on that provision. I'd like to know if Senator Lucero would continue to yield for a question about the language on page 18 of the bill.
Senator Lucero, will you yield? He will yield. Senator Latz.
Thank you, Mr. President. And Senator Lucero, on page 18, there are provisions starting at line 5, new language, going down to line 21, that deal with payments of assessments or fines or fees. And I'd like to know if the language that is there has been vetted by attorneys that practice in the field of fair debt collection.
Senator Lucero, to the question.
Thank you, Mr. President. What I can say about all of the provisions in the language is that the language has been vetted by hundreds, well, at least dozens, if not over 100 different people. That includes Democrat staff, Republican staff, nonpartisan staff, attorneys with legal aid, the chair of the Minnesota Common Interest Ownership, Community Association Institute, which is CAI, the Minnesota Community Association Advocates, which is MCAA. We've had multiple independent attorneys review the language, multiple various property management professionals, multiple homeowners association board members, the Home Ownership Center, the Housing Justice Center, Housing First, Twin Cities Habitat for Humanity, hundreds of HOA residents, both the House Judiciary Chairs, AARP, the League of Minnesota Cities, and many others. So there have been a mix of attorneys and non-attorneys. What I'll say specifically regarding that language is that collection agencies and collection attorneys send thousands of demand letters out each year with the intention of prompting debtor contact to establish a payment plan to pay what they owe. Debtors negotiating payment or payment plans with collection agencies or collection attorneys, and collection agencies and collection attorneys accepting payments under those circumstances does not constitute a Fair Debt Collection Practices Act violation. If an amount has been referred to collection and the homeowner offers full or partial payment, the board merely needs to inform the homeowner that the homeowner must contact the collection agency or collection attorney to make payment or arrange a payment. The bill already provides the right to enter into a payment agreement with the homeowner.
Senator Latz.
Mr. President, I was listening to Senator Lucero's answer very carefully, and I did not hear him state that the language was vetted by attorneys that practice in the field of fair debt collection. This is a federal law which is very complicated, and the violations of which are very severe for anyone who engages in debt collection. The way this is written in the current bill on page 18, it looks to me like, and I've been informed by people involved in the debt collection space that this may well set up a violation of the Fair Debt Collection Practices Act, which is a federal law. So I'm very concerned about that, and it sounds like it wasn't vetted by attorneys that are skilled in that area. I learned early in my career to stay away from that area because it is a trap for the unwary. So I'm very concerned about Senator Lucero's statement. I also did not hear him say that it was vetted by any committee in the Senate or the House. He identified a number of others that have vetted it, and I'm sure there have been a lot of eyes on this bill in the year since the Senate last considered this. But it doesn't sound like this language was vetted by any committee in the House, in the other body, nor certainly not by any committee in the Senate, because it's new language that is coming in here. So I'm very, very concerned about that provision. I also understand that this provision would be contrary to generally accepted accounting principles by requiring application of payments to assessments first without regard to past due amounts. And that would actually shift costs to other owners to make up for past uncollected assessments and costs. Will Senator Lucero continue to yield for a question?
Senator Lucero, will you continue to yield? He will continue to yield. Senator Latz.
Thank you, Mr. President. Senator Lucero, if I can turn your attention to the bottom of page 18, lines 23 to 28, specifically at the end of line 25, it indicates, this is new language that came in, as I understand it, from the House, that the board must make a good faith effort to resolve the grievance, or if resolution is not achieved, refer the unit owner to the common interest community ombudsperson. Do you read that language to mandate the referral to the ombudsperson if resolution of the grievance is not achieved?
Senator Lucero to the question.
Thank you, Mr. President. Thank you, Senator Latz. One of the biggest concerns that we've heard among homeowners is in the area of fines and fees and the ability to have conflict resolution. That's one of the reasons why, and I don't know if Senator Marty's on the floor, but Senator Marty, Senator Pa, and others have had an interest in setting up a mechanism to allow for dispute, and that's where the ombudsman or ombudsperson provision is coming from. Part of that motivation to want to clear up and allow for an opportunity for dispute resolution. The language says if the resolution is not achieved, refer the unit owner to the common interest community ombudsperson. Refer them, and hopefully as part of a dispute, there is opportunity to efficiently resolve rather than to prolongate these disputes, which can be pretty divisive, and it can go on for a long time. And again, when there's any dispute between a resident and a board, the objective is to always achieve resolution as simply and efficiently and friendly as possible.
Senator Latz.
Mr. President, I'm trying to parse out the answer here. The question specifically was, does Senator Lucero read the language in the bill to mandate or require that a referral be made to the ombudsperson if the grievance is not resolved between the board and the homeowner?
Senator Latz, are you asking Senator Lucero to yield for a question?
Yes, please.
Senator Lucero, will you yield? He will yield. Did you hear the question, Senator Lucero?
I believe I did, and I'll just reread. If resolution is not achieved, in other words, the parties can't resolve it among themselves, refer the unit owner to the common interest community ombudsperson. That's what I read there, and it looks like it's pretty clear to me.
Senator Latz.
Mr. President, I'll just make my statement, I guess. The sentence starts, the board must. The board must. And there are two subsidiary clauses after that, which could be given numbers. Number one, make a good faith effort to resolve the grievance, or if resolution is not achieved, number two, refer the unit owner to the ombudsperson. In other words, the referral must take place. Now here's the concern that I have. If anyone in the chamber wants to verify this, pull up the website for the Common Interest Community Ombudsperson's office right now, and it will tell you that they are not accepting any referrals for mediation or dispute resolution. They are not, because they already have so many that have been referred to them, they don't have the capacity to handle any more. I fully agree with the idea and with the goal and the value of referring people to a dispute resolution ombudsperson, but as a practical matter, if this becomes law, it will absolutely flood the ombudsperson's office with disputes that they will not be in any capacity to resolve, and will frankly create just a ton more of angry homeowners in the HOA who will not have a pathway toward resolution. So I would suggest that it ought to be rewritten to say may refer rather than must refer, or that notice must be given of the availability of the ombudsperson, but without mandating a referral to the ombudsperson. That language would be more clear and would I think, be much more workable. Mr. President, I wonder if Senator Lucero would yield for a further question.
Senator Lucero, will you yield? He will yield. Senator Latz.
Thank you, Mr. President. I'd ask Senator Lucero to turn to page 23 of the bill that's before us. And there's some new language in there which also came in from the other body, starting at line 9 that deals with bids. And on line 11, it refers to all bids from a person affiliated with a board member or a member of the family of a board member, or property manager, any member of a family of a property manager or employee. And then the language I'm most concerned about says, must be disclosed prior to consideration or a vote on the bids. I wonder if Senator Lucero would tell me to whom that disclosure is required to be made in this language.
Senator Lucero, to the question, please.
Mr. President, the disclosure is one of the things, so taking a step back. So we all know that work has to be performed. And when work is performed, some, and hopefully many, boards would contract out through a bid process. And they would solicit multiple bids. Unfortunately, during the work sessions and many feedback that we have received, and Mr. President and members, a number of articles, news articles, have been published in the last 2 years highlighting how boards are engaged, some boards and some individual members on boards are engaged in conflicts of interest. Whereas it could be a member of the board or a member of the property management company, or the owner of the property management company might also own a contracting firm, maybe a roofing contractor firm or a deck framing firm. And in some cases, the work is being awarded, which is a clear conflict of interest because of an ownership in both the property management company and the contracting company, without a disclosure of that conflict of interest. And sometimes we've seen in some of these articles that this work is being awarded without competitive bids. So what we're seeking to do in this language is to ensure that there is a bid process for a minimum of 3 bids required, and there's a few exceptions, but that if there is a conflict, that it's disclosed. We're not going to prohibit that, but it simply has to be disclosed, because transparency is an important attribute, and we don't want these contractors or property management companies or individual board members to be profiting in a lack of bid process or lack of transparency process, which comes at the expense of homeowners. So disclosure is definitely something that's important, and that's where the origination of this provision came from.
Senator Letts.
Mr. President, I'm still waiting for the answer to my question, which is, to whom must the disclosure be made under the language in the bill at line 23.13.
Senator Letts, you're asking Senator Lucero to yield again?
Yes.
Senator Lucero, will you yield? He will yield. Senator Lucero.
Thank you, Mr. President. It would be disclosure to the members. It's obviously the members of the HOA who are going to be impacted, because they're going to be the ones footing the bill in a lack of bid process. So disclosure to the members, and we're not prescriptive as to the form, but we're leaving that up to best practices, which is one of the reasons why we're not being prescriptive in the manner. But disclosure is incredibly important, because transparency is one of the values that we promote and stand for here in Minnesota.
Senator Letts.
So, Mr. President, I totally agree that disclosure is important, transparency is important. We ought to do everything we can to avoid conflicts of interest and self-dealing and the whole bit. But the language in the bill doesn't say must be disclosed to the members. It just says must be disclosed. I was thinking maybe it meant to the board. What does disclosure to the members look like? Does that mean that the information must be sent out to all the owners of the units covered by the HOA? Does it mean to the members of the board? And then, I think that really needs to be clarified here, because it doesn't say. Under this current language, disclosure to the public would also cover the requirement in this bill. Does that mean posting the bid on the website of the HOA or on an owner's Facebook page, or posting it on X or Instagram? That's be disclosure, but it doesn't say in the bill to whom the disclosure must be made. The other thing I'm concerned about in that language, if you go back to line 23.11, it says all bids. And then it goes on from, et cetera, must be disclosed. So the way it's written here, it says all bids must be disclosed. It doesn't say that the identity of the bidder must be disclosed. It says all bids. So that would mean, as I read it, the entire content of every bid must be disclosed. That would be the costs that are involved, all the details of the bid. It might well include proprietary business information. It would give competitive bidders, competing opponents' information. Might be proprietary business information, might be all sorts of information that would be disclosed within the bid, because it looks from the language here like the entire content of all bids from the people listed must be disclosed. And I'm not sure if that's what's intended, but the way this is written, the bidder from the bids from these persons could be required to be posted on a Facebook page and disclosed to the entire public, and that's allowed by, might even be required by, the language in this bill. So I'm trying to get some clarity. Is it the bids that are intended to be disclosed, or is it the identity of the bidders that are intended to be disclosed, and to whom must they be disclosed? You know, I asked basically this question in the beginning, and I got a long and valid description as to why we're trying to avoid conflicts of interest, but this seems to be written far more broadly than that. So I don't seem to be getting an answer from Senator Lucero as to my specific question, unless he's got something to the specific question that he could add. I'd love to hear it. I don't know. I'm not allowed to look anywhere other than at the president, but I can see out of the corner of my eye there are people going like this on the floor, but I'm just going to move on. My real point here is that language absolutely needs to be clarified, or you're going to have violations all over the place. It doesn't even say, well, I'll move on from that standpoint. Actually, I'll tell you what will happen if this stays in, and all this proprietary information is going to get disclosed to competing bidders. People aren't going to bid, because they're not going to want to have all of their business information, their competitors knowing what they're doing and how they're reaching their determinations. And ultimately, you're going to end up not getting the lowest cost bidders. You're going to have higher cost bidders, which means the homeowners are going to be paying more to get whatever work is being done. So I think that's a real problem that needs some clarification. And I do have another area of concern. If Senator Lucero maybe I won't even try to ask the question about safe at home, because I'm not sure that I'm going to get a direct answer to my question. I'll just make my statement with regard to that. There was language that was added in the House, did not go through a committee, any committee in the House, was never seen in any committee in the Senate. It was a floor amendment. I'm not sure who vetted the floor amendment. Maybe some of the hundreds of people, or maybe one or two of them, regarding the Safe at Home program. Had that language been considered here in the Senate, it would have gone through I believe, state and local government and through judiciary committee, because it's related to the topic here. The entire bill is a judiciary committee bill. And the conflict that arises, as I am concerned, is that HOAs, especially volunteer HOAs that might not be as well vetted in the ins and outs of this language, have a duty to disclose ownership information, including emails, addresses, and other contact information, which would raise some issues of conflict with the Safe at Home laws, which are designed to protect the identity of victims of abuse. I really support the Safe at Home program, and I don't want to see any problems that might be created here as unintended consequences. And part of the problem is that there's a Minnesota Supreme Court decision, the Harkins versus Grant Park Association, that defines records that might have to be disclosed, and it actually defines records to mean all records, including emails and addresses, as records of membership that are kept by the HOA. So I'm a bit concerned that there's some conflicts there that need to be clarified as well. Now, we should also note that any violations of the Safe at Home program under 515B do carry with it a cause of action for a lawsuit against anyone who violates the requirements. So I am concerned here that this is setting up a conflict in the statutes, the remedy for which could be a lawsuit, private cause of action. Now, I'll be candid, I did ask the Secretary of State's office to take a look at it this morning. Apparently they were not consulted because they weren't aware of this provision. It doesn't appear till I left a message for the Secretary of State at 9 o'clock last night, and they were all kind of scrambling to take a look at it this morning. So, number one, I'm very concerned the Secretary of State's office was not consulted, apparently, with regard to a Safe at Home provision inserted in this bill on the House floor. And secondly, their view is that as a practical matter, there seems to be compliance going on. Folks are working it out informally to avoid violations, and that may well be the case. But if you've got volunteer HOAs that are not well versed in this, that are making disclosures consistent with the Minnesota Supreme Court decision in Harkins versus Grant Park Association, we may be setting up a whole other category of people that'll be violating the Safe at Home requirements, and most importantly, maybe setting up victims who are trying to stay safe from having their whereabouts disclosed. So I also did not hear Senator Lucero. I should also note that's a misdemeanor crime also to violate the Safe at Home Act, just adding that parenthetically. Associations could be facing punitive damages and attorney's fees, which is part of that cause of action. The other thing is, normally when we have amendments to MCIO, the Common Interest Ownership Act in Minnesota, they're vetted not only by attorneys that spend a lot of time practicing in that space, but also by the State Bar Association itself and their section that deals with this area of law. Now, I heard Senator Lucero saying that the chair of that section was involved in some of the drafting, but I didn't hear anyone state that the Bar Association had gone through the vetting process itself, because they've got lawyers that practice on both sides or all sides of this issue that read this language very, very carefully. They try to understand how the language might be impacted or might impact other areas of the law as well. And so much of this language hasn't been heard in any House committee, hasn't been heard in any Senate committee. A couple of the pieces of language were offered on the Senate floor as floor amendments that were adopted on a voice vote. I doubt very much there was a real thorough consideration of the specifics of the language itself, although I was candid, I wasn't on the House floor at the time. These are things which would have been, should have been vetted had they been part of the original bill through the Senate Judiciary Committee, but they weren't. I guess my main point, members, is that not that I oppose the whole goal of the bill. It's laudable and important, but that if we're going to do it, we should do it right. We need to do it carefully. And I think that needs to happen now before we, as a Senate, simply give up our right to vet these pieces carefully in a public hearing with stakeholder input and analysis that would happen in a conference committee, and instead just accept what the House has sent over to us. I think that would be an abdication of our responsibilities as a Senate. Sometimes we do that on bills that are less complicated or have simple changes that we've heard 3 weeks before. We all remember what was in there from the floor debates and discussions at the time. I will reiterate, members, this was heard a year ago on the Senate floor. There have been, as I understand it, 13 delete everything amendments that has gone through the process in the other body since that time. We've got a 55-page bill in front of us here with a lot of new language in there that we simply have not vetted, and the State Bar Association has not vetted, and that we need to vet in order to make this right. So for those reasons, members, I would encourage a no vote on the motion to concur so that this can go to conference committee and get the proper vetting from the public as well as from the Senate.
Members, we are on Senate file number 1750, and we're on the motion to concur in to the House language. Senator Seeberger.
Thank you, Mr. President. I've been listening to the concerns raised by Senator Latz, and I think he has raised some significant concerns with regard to the language changes made in the other body. And I also have concerns with regard to the bill's author's inability to answer these questions, and instead pivoting to talking points about the reason why we need this bill. We do need this bill, and we need the changes that the bill addresses. But I have the same concerns as my colleague with regard to the vetting of this language. As we know, the Senate is the more deliberative body, and the questions posed by Senator Latz demonstrate the scrutiny this bill did not have and still needs. In fact, this turned into sort of a quasi-judiciary hearing, but we don't have the ability to fix the issues that have been identified. I support the aims of this bill, and I believe it's important to the people of Minnesota, and I want to see it pass, but I want to see it pass the right way with the right language. I'm worried that concurring with the language that was sent over by the other body will advance a bill that is not fully vetted and which contains potential conflicts. I can think of at least 2 bills, Mr. President, that we are still dealing with the after effects of due to their not being fully vetted. One was the teacher pension piece that occurred back in 1989. We are still fixing those problems due to a floor amendment that was added to a bill, not fully vetted, in fact, voted down by the Pensions Commission. That is the wrong way to make laws, and we are still dealing with those problems today. The second is the ban on seclusion we enacted in 2023. That was not fully vetted. We are still dealing with those after effects today. Attempts to rush legislation through is a dangerous practice, and it leads to problems that can be forced into the court system for resolution or foisted on future legislatures to deal with. And I think it's a dangerous, dangerous way to enact legislation, to try to force something through that's not ready when issues are clearly identified. For these reasons, Mr. President, I would urge caution in this body in concurring with the bill that's before us today. Thank you.
Senator Pye.
Thank you, Mr. President. I want to encourage members here to please vote to concur. And I want to respond to a lot of the questions and concerns that have been brought up by members. One, the question and concerns regarding vetting. Every single member of this Senate has had an opportunity to vet this bill, to review it. The last 3 days, they have had an opportunity to look at this bill, ask questions, have the discussions, whether it was with the two chief authors, myself and Senator Lucero, with stakeholders, with lobbyists, with homeowners associations, with anyone they want. Members, committee members of the Senate Judiciary Committee, they're a part of this Senate, aren't they? Or are they not part of this Senate? They've had the chance to review the bill, to ask questions, to talk to anyone they want. If they did not do that and raise up those questions, that's on them. Every single Senate member here have had a chance to review this bill. I want to review a lot of the misconception and flat out, I would say, misinterpretation of the language that's in this bill. And I'll start with the safe at home. The safe at home already exists right now, and nothing in the addition to it in our bill changes anything about that. It does not conflict, period. Where is the confliction? I love to understand that. Because right now, if you look at the safe at home, it is added. Look at where it's added in the bill. It's added under rights of action, retaliation, prohibition, attorney's fees section. It simply says the current Safe at Home Act is now something that if someone who has been a victim of domestic violence, who is protected under the Safe at Home, who has given their homeowners association notice that their information should be protected, which under the law right now they can do. Changes absolutely nothing. The only change is that if the homeowners association violates that, they have a right of action to seek damages. And they should. Because as someone who owns a home, protected under this, have notified their HOA, and now their information is all over, it is no longer protected, and they have to move their family out of that home, they should be able to seek damages. I hope that they do, because now it has disrupted their lives. Now they have to move out of their home because someone else did not make sure that the information that was given to them to protect their identity was not doing so. It does nothing with the current law. It does not conflict. It only says they have the right to seek remedy. That is it. I want to also address the concern that was brought up about board members being able, HOA members who are being able to vote at board meetings. Right now, homeowners in our current law already has a right to vote at board meetings. HOA boards can call for an homeowner's members board voting at any board meeting and give notice, and members of that HOA, homeowners, can come and vote. There are multiple ways that people can vote. They can vote by mail, they can vote by email, they can vote by proxy, they can vote in person. And if there's a threshold of 51% or more that is reached in favor of anything, whether it's a fine, that we're talking about specifically in this provision, $100, then that is something that can be adopted. If it does not meet that threshold of 51%, then those fines that are above 100 cannot be adopted. That is what the language in here says. The statement that speaks that associations can never recover legal fees or collect costs because now there has to be a process in which payments are applied. Payments must be applied to dues and assessments first before they're applied to fines and fees. And somehow that is a conflict or a violation of GAAP, and I'll tell you what that means. It's a general accepted accounting principles. There is absolutely no conflict to what we are putting into law to the general accepted accounting principles that HOAs use. In fact, GAAP itself does not dictate a single mandatory order for applying partial payments. What it does do is it requires consistency, it requires disclosure, it requires substance over form, it requires separation of funds. That is it. What our statute does is that it tells HOAs how to allocate those payments. GAAP tells the HOA how to record that payment. It is not in conflict. In fact, it works beautifully together because it gives clarification and clarity to HOAs and how they should document that. Another point that was brought up about that if HOAs all of a sudden takes partial payment or full payment of dues or assessments, that somehow it is going to conflict with the FDCPA. That is absolutely untrue. If you would read the actual language and read the law, you would find that SF 1750 language doesn't cause FDCPA problems. It actually clarifies that HOAs and collectors what they must do. It clarifies that HOAs can take a payment and they have to communicate that to their debt collector, collection agency, attorneys that they use. Those attorneys must then update the amount that's owed in their attempt to collect. It absolutely has no conflict whatsoever. The only time where there's going to be an issue is if an HOA takes payment and doesn't communicate that at all. That's on them if they don't communicate that to their debt collector and attorneys, that they've taken payment. But it should not prevent homeowners from being able to make a payment on the dues and assessments and the fines that are before them. That's exactly why HOAs send debts to debt collectors, to get homeowners to pay. And then when homeowners pay, they don't want it? That's ridiculous to me. There has been specific cases in the state of Minnesota where homeowners have actually gone to property management and handed them a check to pay for what they owe. And because the property managers want to continue foreclosure, they've rejected that payment. Are we saying that that's okay to reject payment so you can pursue foreclosure? Because that's what's happening right now in the state of Minnesota to thousands of homeowners. And this is what's going to stop it. And say, you have every right to collect all the money that's owed to you. But if a payment is presented by a homeowner, you must take that payment. There is absolutely no conflict in this law. And it does not conflict with the Federal Debt Collections Protection Act. It absolutely does not. There was a comment about bid and bid document disclosure. It is very, very clear in the bill, and I'll point exactly to where it is. And had anyone read the bill, or especially the ones raising concern, had they actually read the bill that they're talking about, the provisions they have concern on, they would see it clearly states on here, the association must maintain a record of the bill selection process, including the criteria used and the contracts awarded for the last 6 years, and make those records available to unit owners at cost. Where does it say on here that they could post it on social media, Facebook, TikTok, Instagram? Where does it say they have to post all bids? It doesn't say that in here. I don't know where people are getting these ideas, literally, as I'm pointing these points out to people. Nothing in this language says you must publicly disclose bids to the public. It says you must keep records of it and make it available to unit owners. Please read the language. Please bring up these concerns. And when they do, I'm not just pulling answers from the air. I'm pointing out to the language, and please do so as well. If you truly have concerns, point out to those languages. Another concern that was brought up is insurance contracts not being exempt from bidding. There's already laws in our language here that says insurance can be exempt from the 3-bid exemption if they fall into the criteria on here, which they do. If an insurance requires certain contractors, if they require certain items to be fixed with a certain cost, and they're not able to find appropriate bids to be able to meet those requirements, they've done their due diligence and are now exempt from the 3-bid. That's already in this language. We do not need to add another clause that exempts them when it already exempts that specific scenario and any scenario that has to do with insurance that do not meet these criteria. There was a reference to the ombudsperson's office. If an HOA is required, mandated, to refer homeowners to the ombudsperson, but I want you to read where it is in the language that it says that. If a homeowner has a grievance, the HOA must make a good faith effort to resolve those grievances. And if there is no resolution between the homeowner and the HOA refers them to the ombudspersons. That is in their disclosure forms. That is in the proceeding. There is nothing in there that says the homeowner or the HOA must go to the ombudsperson. It simply says, if we have a dispute and it's not resolved, here's an information sheet. You can get resources and information and use a ombudsperson's office if you see fit. HOAs understand what the resources are available out there. Homeowners do not. Not every single homeowner that lives in a homeowners association is even going to know that they have a resource such as a ombudsperson's office. They're not even going to know that. And the fact that when a dispute comes along and can't be resolved, we're asking that homeowners association just give that information out to homeowners so they understand that they have resources. That's not something that we should be saying should be eliminated from this. That's something we should be encouraging people to do. And today is May 6th. Currently, right now, we do not have an ombudsperson in that position. This law does not even go into effect until January 1st of 2027. We're more than 7 months away from that date. And I understand that we should get someone in that office as soon as possible. We absolutely should. But if we don't have someone in that office in 7 months, we have big problems, much bigger problems than the asking people to just simply give that information out. Members, a lot of the things that have been brought up, misconstrued, misstated, is simply inaccurate. And I hope that you will see that there have been dozens and dozens of people who have worked on this bill, who has reviewed this bill line by line, word by word, who have worked on this, and this is a good, solid bill. There is nothing in this bill that needs to change. Please concur.
Senator Letts.
Mr. President and members, here's what I just heard Senator Pa say. If you wanted to, you could vet the bill on your own. If you had actually read the law, you would agree with Senator Pa. Had anyone read the bill, especially those who are raising questions, you would see it Senator Pa's way. There's got to be some decorum here in this body where we don't disparage the motives or the good faith or the diligence of people who are raising questions as a means of suggesting that their questions are wrong or illegitimate or somehow erroneous in fact. I asked very specific questions of Senator Lucero. And frankly, after a long dissertation, I had to ask the question again because I couldn't get an answer. I didn't even ask Senator Pa any specific questions, but I'm going to right now, if Senator Pa will yield.
Senator Pa, will you yield? She will yield. Senator Letts.
Mr. President, Senator Pa, what's the effective date of this bill?
Senator Pa, to the question.
1 minute, President. The effective date of this bill is as soon as it is enacted.
Senator Letts.
President, but
Senator Pa.
But when I referenced January 1st, that was for the ombudsperson question before. Just want to clarify that.
Senator Letts.
Well, Mr. President, Senator Pa told me in a meeting before we came to the floor yesterday that we would have time to come back and fix this next year because it's not effective until 2027. So now I'm really confused. If Senator Pa had actually read the bill, she would know, without having to look it up, that the bill was effective the day following enactment, or some provisions are effective January 1, 2027. So I have a follow-up question if Senator Pa would yield, please.
Senator Pa, will you yield? She will yield. Senator Letts.
Mr. President, Senator Pa, will this legislature be meeting between now and the time any of the effective dates in this bill take effect?
Senator Pa, to the question.
Mr. President, I find Senator Latz's statement that I think that anything that happens in this bill can come back next year or in the time from now until next year as a completely untrue. I never at any point ever said that.
Senator Latz.
Mr. President, I'm going to ask the question again because I was in the meeting with Senator Pa and with Representative Bonner and with a stakeholder lobbyist in which I was told that by Senator Pa. But she wants to call me a liar on the floor. I guess that's her right. But she didn't even answer my question.
Members, we're going to conduct ourselves as the wonderful senators we are. We know, I'm just saying this to everyone because you're doing it in front of everyone, that we have to have the appropriate demeanor and decorum. That is not to impugn each other. That is not to use aggressive language on the floor. We can debate. I don't mind that. I don't even mind you yielding and asking questions. I'm just telling you, according to our rules and Masons, and my instructions that I gave even at the beginning when I knew that we were going to have longer times on the floor and things were going to get a little more heated, that I just asked you all to breathe. Okay? So with that being said, I'm going back to Senator Latz.
Mr. President, will Senator Pa yield to a question?
Senator Pa, will you yield? She will yield, Senator Latz. Senator Latz.
Mr. President, Senator Pa, will this legislature be meeting between now and the time this bill takes effect?
Senator Pa, to the question.
No, this legislature will not be meeting between now and this bill takes in effect. And President Champion, I am not impugning anyone's integrity, but I do not appreciate people putting words in my mouth that I never said. And I want to remind Senator Latz that in that meeting, it was not I who said that. I would wish that he would recall what the conversation was, but there was no time, in effect, did I say there was problems in this bill that I'd be happy to bring back next year. Never. I've always said there is nothing wrong with this language, pointed out to why there's nothing wrong in this language.
Senator Latz.
Mr. President, will Senator Pa yield to a further question?
Senator Pa, will you yield to another question? She will yield to another question. Senator Latz.
Mr. President, Senator Pa on line 23.11, after the period it reads all bids from a person. What does all bids mean?
Senator Pa, to the question.
I see that language. All bids from a person affiliated with a board member, a member of the family of a board member, a property manager, or any member of the family of a property manager or employees must be disclosed prior to consideration or vote on the bids. All bids means all bids that may have a conflict of interest. That's what it means.
Senator Latz, the floor is yours.
So it sounds like the content of the bids, all the bids, not just the fact that there is a bid, not just the entity from whom the bid is brought, but all the bids must be disclosed. Okay, so I appreciate the clarification. Members, I think that needs further clarification in language before this bill becomes law. Will Senator Pa yield to another question?
Senator Pa, will you yield to another question? She will yield to another question. Senator Latz.
Mr. President, Senator Pa on line 23.13, it says must be disclosed. Does it specify that it does not, it's not allowable to disclose it to the public?
Senator Pa, to the specific question.
Yes, it does. The very next sentence, where it says, a written record of the disclosure must be retained and recorded in the meeting minutes. Meeting minutes are not available to the public. They're available to homeowners that live in that HOA. And these are the bids that have conflicts of interest, family members, affiliates, of board members, of property management companies. We're not talking about all bids, period, now publicly available. You could post it on social media and everywhere else.
Senator Latz.
Mr. President, I actually did not hear an answer to my question there, because my question was whether or not there's anything in here that prohibits the bids from being disclosed publicly. And the answer was where the written record must be maintained or retained and recorded in the meeting minutes. So the disclosure could be to the public. It's just that when that happens to the public, the meeting minutes must reflect that disclosure. That's different than Senator Pa in her initial floor remarks stated that the disclosure would not be to the public. But it just doesn't say that in the language, members, and that's my point. It doesn't say that in the language of the bill. So disclosure could be to the board members. It doesn't actually say that either in the bill. Disclosure could be to the homeowners and not to the board. Doesn't say that either in the bill. It does say wherever the disclosure is made, the written record must be retained and recorded in the meeting minutes. Members, we can have a full judiciary hearing right here on the Senate floor. It seems that we are. I'm asking very specific questions about very specific words in the bill. And if we don't get it right, that alone could lead to a lawsuit or a clarification or an aggrieved party bringing a civil action and the incurrence of hundreds of thousands of dollars of attorney's fees and a year or two of delays in resolving whatever the issue is if we don't get it right. That's why we have a process, members, is to do our best to get it right before it becomes law, not afterward when we're cleaning up a mess. And we all know, yes, we do come back and we clean up errors and we think we got something clarified and a court disagreed or there was some conflict that we had to sort out. We improve our bills all the time. But not because we didn't try to get it right the first time. With some exceptions, apparently. Senator Seeberger identified a couple of those exceptions that she knows in particular, when we made decisions on the fly on the floor, which sounded great. We all liked the intent of, but which, if the language isn't right, and it's not right, words matter. We're not just writing press releases. We are putting statutes into the statute books that have the force and effect of law. Why would we not want to do everything we can to get those words right? Will Senator Pa yield to an additional question, Mr. President?
Senator Pa, will you yield? She will yield. Senator Latz.
On page 18, I want to take us back to this question about the concern about the Fair Debt Collection Practice Act, because Senator Pa is asking us basically to take her word for it. As she very emphatically stated multiple times, there is no conflict. There is no conflict. Well, I know that Senator Pa is not an attorney that practices in the Fair Debt Collection Practices Act field. Look, every one of us here on this floor brings our own skill sets, our own niche expertise, the value that we bring, our life experience and everything. And that's what makes this a great Senate, because we bring all those perspectives and knowledge and expertise to our decisions here. Some of us are attorneys, and we're reading this very, very carefully, because the grammar matters, the words matter. And I heard Senator Pa, when she addressed the FDCPA, state that the only thing that's required here is that partial payments be accepted. and that the only referral that's necessary is referred over to the collection agency. But that's not the only thing that's in here, members. What Senator Pott did not tell you is that line 18.10, parent H states a payment by a unit owner must be applied to assessments for common expenses and special assessments first, before it is applied to fines, fees, or other assessments, except that the payment can be applied. And then it lists another 9 lines, members, that prioritizes the manner and order in which payments, partial or not, must be applied. Members, I am respectfully submitting that that language may conflict with the Fair Debt Collection Practices Act. The information that I have gives me pause on that point. And other than an emphatic denial of that conflict, I haven't heard anyone on this floor actually clearly identify how this mandatory prioritization of partial payments before or after collection proceedings have begun, by the way, and the rules apply. There are different rules in the Fair Debt Collection Practices Act for before and after. This language has a mandatory order of priority. Members, why would we not sit down in a public hearing with experts in the FDCPA and make sure that we are not putting lawyers and board members and unit owners in a position of violating federal law? Because the information I'm getting is that this bill will do that, or it might very well do that. Language which apparently was not vetted in any committee, as far as I'm aware. Members, I'm going to say once again, I don't disagree with the goal here. But the question before the body is, do we concur with the language, the changes that were made in the House? Apparently, hundreds of people being involved in this. Between the last time the Senate saw this 365 days ago and today. Don't we have some obligation to have a conference committee to vet the changes in public with public input, not behind closed doors conversations, not voice votes on the floor of the other body where 134 members all are sitting around, or not on the floor where others are voting for them, not even paying attention. I served there, I know how it works. We are the deliberative body. This is our duty to do this right. And lest anyone say we got to rush through this process, or we're not going to get a bill passed this year, we don't have time to fix any of this. First of all, you've got to acknowledge that maybe something needs to be fixed, and apparently the two main authors of the bill here in the Senate don't even see one word that's wrong here. I respectfully submit that I, as the chair of the Senate Judiciary Committee, as a practicing lawyer for almost 40 years, as someone who has vetted hundreds and hundreds of bills that have come through the committee, suggest that there's some language issues here, there's some lack of clarity here that's going to cause a real problem. that we can and must fix before these words go into our statute books as the law of the state of Minnesota. The only way we get to that repair of this bill is by not concurring with the House amendments. And members, there are other lawyers on this floor here, Senator Seeberger, an experienced lawyer like me, as a member of the Judiciary Committee. I'm happy to help work through some of this language. I'm sure others would be happy to work through this language. But if you vote to concur, there will not be that opportunity. I doubt any one of you are going to be paying the lawyers' fees when they sort this out in the courts. But someone will be. Let's do our job, members. Let's vote not to concur. Let the conference committee do the job that conference committees are supposed to do.
Members, we're on the motion to concur.
Mr. President,
Senator Pye.
I think I was asked to yield for a question probably about 6 questions ago and 10 minutes ago, and I honestly, I've forgotten the 6 questions. I think I remember 2. And so I'm more than happy to answer those questions, the ones I remember. One is, I believe Senator Lance asked about the FDCPA and how this may have a conflict. This section with payment and fines and how they should take those payments and fines in the order in which they should and how they should apply those. I did not go through every inch of this bill as I was only answering the questions that he directed at me. And so when he said I missed these things and did not talk about this, I simply didn't miss them. That wasn't part of the question. I wasn't trying to hide anything from anyone, just wasn't asked. But now that he's asking, I'd be happy to go over it. It says clearly in this section that associations may not refuse to accept payment from a homeowner in any amount for any assessment, fines, or fees. And then it goes to explain that payments must first be applied to assessments, dues, and expenses before it can go to fees, fines, and other things in here. And it lists what those things are. And the specific of this language is specifically to prevent HOAs from taking payment from homeowners, applying those payments to fines and fees and never to the dues and to assessments, so that they can force and continue a foreclosure on someone because they applied payments to fines and fees and not to the actual dues. Because to the actual dues, they could actually then now put a lien on their property and start the foreclosure process. And that's for those bad actors that currently right now in the state of Minnesota practices. And for some of you who may not know, HOAs can start the process of foreclosure on any homeowners who are late 1 day from the due date of their dues and assessments. 1 day, that's it. Not 30 days, not 90 days, not 180 days, 1 day. That should scare the hell out of you, and it scares the hell out of the 1.7 million homeowners that live in an HOA in the state of Minnesota. And this provision says they have to apply the payments to those dues and assessments before they do the fines and fees to prevent that exact thing from happening. I want to agree with Senator Lance that words matter. Our bill language matters, and this should be done right. And I agree, it absolutely should. I'm also one that loves to read language word by word, sentence by sentence, and want to make sure that it is right. In this bill, the words, the language are right. We may have differences in how we see things, members. But I want to tell you that the things that have been brought up to my attention, I have addressed them with the members who have. The things that have been brought up here today on the floor, I have addressed those. I can't change people's minds. They can make up whatever minds that they want. But what I can do is I can explain the language that's actually in the bill and point to it and clarify what that language actually means and read through that language. I hope that our members will remember the hundreds upon hundreds of homeowners who have come to all of our committee hearings, who have emailed us, called us, came to our listening sessions, that they will remember the task force that was created by this body to look over the issues with CIC and HOAs and make recommendations, where a core piece of these legislation came from the task force, that they will remember the work of this bill and the issues that this bill is supposed to address, and the people it's supposed to protect. And I'm not going to keep delaying this bill another year, 2, 3, 4, 10, because members want to go through word by word and say there needs to be this instead, when the whole paragraph already clarifies what that really means, but they think one word is missing that further clarifies it, even more so than it already is clarified. That's ridiculous. If there are true conflicts, there are true vetting that needs to get done because language is incorrect, language needs to change, I'm more than happy to do that. But I do not see that, members. Please concur.
Members, I'm going to provide another reminder because we're using language on the floor that is inappropriate. I'm going to call your attention to Section 121 of Masons, and specifically it talks about the use of disorderly words in debate. No member may indulge in personalities, impugn motives of members, or use indecent or profane language. We're getting loose with our language on the Senate floor. I'm asking you to refrain from using inappropriate words or indecent words. I don't want to have to go through the process that it talks about here, what to do when someone is using disorderly words. So I'm going to remind us all of that because I know we get a little heated during debate, but I want you to refrain from violating the rules. Now, members, we are on motion to concur. Anyone else before I go back to the motion with Senator Lucero? Anyone else? Senator Lucero, give us your final words so that we can vote just on the motion to concur, because if they vote to concur, then you have to go through the bill. But you know where we are. We've heard everything a lot about the bill already. Senator Lucero.
Thank you, Mr. President. You spoke more words than I was going to. I was going to remind members that the language is well vetted, hundreds of people. It is ready for prime time. People are desperately waiting for this. I encourage members to vote green to concur.
A roll call was requested and a roll call was granted. The secretary would take the roll on the motion to concur. A green vote means you are in support. A red vote, it means that you do not want to concur. Members, please vote. Senator Hurd, for those voting pursuant to Rule 40.7.
Mr. President, Senator Port votes aye.
I'm sorry, who'd you say?
Senator Port.
Senator Port votes aye.
Senator Murphy votes aye.
Senator Murphy votes aye.
Senator Marty votes aye.
Senator Marty votes aye.
Senator Rest votes aye.
Senator Rest votes aye.
Senator Westlin votes aye.
Senator Westlin votes aye.
Senator Carlson votes yes.
Senator Carlson votes aye.
Thank you.
Senator Jasinski, for those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Abler votes aye.
Senator Abler votes aye.
Senator Johnson votes aye.
Senator Johnson votes aye.
Thank you, Mr. President. Senator Lang votes aye.
And Senator Lang votes aye. All members having voted who desires to vote, the Secretary will close the roll. There being 59 ayes and 8 noes, the motion to concur prevails. Now we're on the bill. Senator Lucero, now you can describe the rest of the bill.
Thank you, Mr. President. There isn't anything else that I can think of that needs to be said. I could stand for questions, but it is a final passage. I encourage a green vote. Thank you.
We are now going to give the bill its third reading. The Secretary will give the bill its third reading.
Senate File Number 1750, a bill for an act relating to common interest communities, modifying powers and duties of common interest communities.
Third reading. Now we're on final passage. Can I go forward? The Secretary would, is there someone else that wanted to say something? Senator Rasmussen.
Thank you, Mr. President. I look forward to supporting this bill today because of the inclusion of a really important housing provision that will help make housing more affordable for Minnesotans and help more Minnesotans get into home ownership. And that it came from an amendment that the Senate put on this bill when we heard it on the floor a year ago today that will no longer allow local units of government to require a feature that would necessitate an HOA. And we have seen, unfortunately, that we have local units of government that are pushing infrastructure and amenities onto new developments using HOAs as a tool to do that. I've heard that if you look in Minnesota, that more than 80% of new single-family homes constructed in our state are within an HOA. And I think it's important if a developer, if a family, if a community wants to have an HOA, they're allowed to do so in this bill. But you can't have a local unit of government force those types of amenities on a community if they don't want it. And so I appreciate the bill authors including that provision in the bill and keeping it in this final version. I think it will be a positive step forward to bring down the cost of building new homes here in the state of Minnesota.
Any other discussion? Senator Powell, we're on final passage as amended by the House.
Thank you, Mr. President. I just wanted to take a minute to thank all the homeowners for the last 2 years, the hundreds upon hundreds of homeowners who have reached out, shared their stories, who have come out to our committee hearings and testified time and time again in support of this bill. I want to recognize them because their lives, their families' lives were severely impacted when their homes were foreclosed on and they had no place to live, when they lost equity in the one place in which all their savings was in. When they lost their savings because of all the exorbitant fines and fees of HOAs that was implemented and assessed to them. When I hear the stories from Minnesotans, I am so proud that we're going to pass this bill so that we stop that from happening to one more family. 1 in 4 Minnesotans live under an HOA right now. And we have few laws that actually protect homeowners that live in a homeowners association. And this bill will finally give oversight that's much needed. Losing your home to foreclosure over a few $100s, or as one story in the newspaper said, $56. A homeowner lost their home for $56 in fines and fees. Losing your voice at board meetings because boards can shut you out of their board meetings, close the door, and decide they don't want to listen to you. Property management companies and board members can hand over overpriced contracts to their affiliates and friends and family and get a kickback, and it's totally fine. This will stop that. It will stop HOAs from charging homeowners a $250 attorney fee per hour that we've seen in one instance from one of our constituents for simply asking a question. This is long overdue reform, and when we pass this today is a victory for all homeowners that live in HOAs. And it is good legislation. It is overdue legislation. Thank you, members, for voting for this. The homeowners that live in HOAs all across Minnesota, thanks you.
The secretary will take the, oh, I'm sorry. Are you okay? Okay, Senator Lucero.
Thank you, Mr. President. I just wanted to thank one more time, because it cannot be said enough. Thank you to Senator Pa for being a partner on this for the last nearly 2 years. And I could see in the back of the chamber there that Representative McEwen and Representative Bonner, also a huge thank you. Representative Bonner was the point person in the other body. She is a workhorse. And I am so appreciative of her and all the coordinating efforts that she went through in the multiple iterations of receiving feedback, tracking that, and getting the four of us together these many, many, many times in the last 2 years to bring us to the point where we are today. So a big thank you again to this team. Thank you to Mr. Elwood and the many, many stakeholders that have put countless hours into this. Thank you, Mr. President and members. The time is now to bring this HOA Resident Bill of Rights to law. Vote green.
The secretary will take the roll on Senate File number 1750 as amended. Members, please vote expeditiously. Senator Hurd, for those voting pursuant to Rule 40.7.
Mr. President, Senator Carlson votes aye.
Senator Carlson votes aye.
Senator Port votes aye.
Senator Port votes aye.
Senator Murphy votes aye.
Senator Murphy votes aye.
And Senator Rest votes aye.
And Senator Rest votes aye. Members, we're on a roll call vote. We're not supposed to be at anyone else's desk at this time. Senator Rasmussen, for those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Jasinski votes aye.
Senator Jasinski votes aye.
And Senator Johnson votes aye.
And Senator Johnson votes aye.
Mr. President, I'm waiting on one more.
Senator Herr?
Mr. President, Senator Marty votes aye.
Senator Marty votes aye. Senator Rasmussen.
Thank you, Mr. President. Senator Lang votes aye.
Senator Lang votes aye. All members having voted who desires to vote, the secretary will close the roll. There have been 56 ayes and 9 nays. The bill is passed and is titled agreed to. Remaining under motions and resolutions, Senator Herr for a motion to designate special orders.
Mr. President, pursuant to Rule 26, I designate the following bills to be made special orders for the immediate consideration.
Members, the special orders list is on your desk, dated May 6, 2026, and we will begin with Senate file number 4476. Senator Hoffman.
Thank you, Mr. Chair. Mr. President, sorry, I was thinking we were trying to be expeditiously in our conversations today, and so I'm going to be very expeditiously in this presentation, Mr. President. This is Senate File 4476. It establishes some things that you want to know about, Mr. President. There are key provisions in the bill I want to highlight, and I will be expeditiously when I do this. Establishing a continuity of care team at the Department of Human Services to ensure that a continuity care plan is ready for each client whose services are disrupted. This is a top priority in our committee. This is really, if you look at it, Mr. President, this was really the #1 priority for us because we kept hearing about people, and there were people that were not getting the services they needed because of service disruptions. We can't have that. Greater transparency requirements when a for-profit entity purchases a non-for-profit long-term care facility. We protect the safety and well-being of loved ones in long-term care by requiring the appropriate nursing levels. We help long-term care residents and their families afford care by protecting against the unreasonable fee increases that exceed the cost of the CPI inflation. If you look at that I think is pretty fair. Creates a min-choices assessor team at the Department of Human Services to help the counties process assessment backlogs more quickly. We increased the family residential services framework rates for service recipients with high needs. I want to make sure, Mr. President, that a big thank you to Senator Liskey for his hard work on this issue. He really did what is needed. I wish he was in our committee, Mr. President. I know he will have an amendment later to improve upon this language. And again, we wouldn't be here having this conversation if Senator Liskey didn't raise for us the issues that he was hearing from individuals and just for what that is. We also repeal the waiver reimagine plan because the process of developing has not been inclusive or transparent for individuals and families. One would just have to look back at the history logs to see the good senator from Anoka is actually the one who brought this waiver reimagine plan, and I don't think it's turned out to be what he envisioned it to be when he started it. So finally, Mr. President, this bill takes a substantial step in buying down the $178 million assumed savings cut to human services in fiscal years 28 and 29. If this legislature does not act specifically on that, this cut will be passed along to the competitive workforce factor in the disability waiver rate system, rates, and the county cost share in residential services. We need to act on that now so that there aren't some future disruptions in that. This budget buys down that cut completely in fiscal year 28, and then it buys a portion of it in its tails, Mr. President. And so with that is Senate File 4476. Thank you.
Senator Liskey.
Thank you, Mr. President. Mr. President, as Senator Hoffman alluded to, I have an amendment, Amendment A44.
Senator Liskey offers the A44 amendment. The Secretary will report the A44 amendment.
Senator Liskey moves to amend Senate File number 4476 as follows. Page 32, line 16, delete. This is the A44 amendment.
Senator Liskey, to your amendment.
Thank you, Mr. President. Mr. President, this amendment is good faith efforts on compromise. Compromise is always a challenging thing, especially when we're talking about people's lives and their livelihoods and maybe with the help that they might need. With this amendment, we are going to modify the new flat rate system that we had enacted in, I believe, 2023. It's unfortunate that this flat rate system even got introduced, but it also was unfortunate how the system came to be created as a whole in 2013. Senator Hoffman asked me many times, where was I in 2013 during this discussion? And the answer was chiropractic school. I was not here. I was not part of the political system at that time. And so I wasn't around to help guide the path. And unfortunately, I don't know that this is a perfect fix, but it may get us at least through the next year while we try to find a solution. This will increase the rates for the higher level tiers for those that are on FRS. FRS being Family Rehabilitative Services or family services in general. They're going to be helping individuals that are foster home disabled adults and disabled children. The unfortunate part is that some of these family housing units have closed due to the changes of the flat rates, and so right now we're dealing with up to 29 kids who have been displaced from their homes, and I'm hoping that by doing this fix, we can at least get them back in their homes for a short duration. It increases the third, fourth, and fifth tiers by 20%. It increases the sixth tier by 30%. And then specifically around those kids, it adds a $50 per day increase for 1 through 3 and a $100 per day for 4 through 6. It will cost some money. It does. Unfortunately, those services actually are super important because if we don't do this change, those individuals will end up in crisis care. And in fact, there are a couple that were just calling me today letting me know that they are in crisis care. And crisis care actually costs us more money than keeping them in their homes. And the other part is that people don't understand is the human side of the equation. These people have had this connection with these homes for long periods of time, sometimes their whole lives. And with that, we are now taking them out of their homes and sending them to hospital settings or center-based settings where they may not actually find the care that they need, and they may not have a stability that they definitely deserve. And so with that, I urge a yes vote on the A44. Thank you.
Senator Hoffman to the A44.
Mr. President, you know, when you get an Academy Award or you get a Grammy nomination, you have to have consensus. And in this case, Senator Liskey did that, so it's a friendly amendment.
All in favor of adoption of the A44, say aye. All those opposed, say no. The motion prevails. The A44 is adopted. Senator Frentz.
Thank you, Mr. President. I would like to offer the A50 amendment.
Senator Frentz offers the A50 amendment. The Secretary will report the A50 amendment.
Senator Frentz moves to amend Senate File number 4476 as follows. Pages 54 to 55, delete sections 2 to 6. This is the A50 amendment.
Senator Frentz to your A50 amendment.
Thank you, Mr. President, and thank you, members. Members, one of the challenges we face in managing the business community is to try to find the right balance between worker and owner. In this bill, we have some staffing mandates, and in my district, I've had members of the community that own assisted living and nursing facilities reach out to express concern. We've engaged on the topic, and the A50 would remove those sections of the bill which require staffing mandates. There are arguments on both sides. I'm simply responding to what they're asking for in my district. Also, Mr. President, on lines 1.5 to 1.9 of the amendment, the money that is saved by those changes is redirected to attempt to offset potential cuts in 28-29 to long-term services and supports. Regardless of where you are in the A50, I hope we agree we need more funding for long-term service and support. Members, this is something that responds to concerns by constituencies. We want to keep facilities open. I have an example for members that in my district, a small operator has 6 places within about a 50-mile radius of Mankato. His estimate is that the staffing mandates would increase the cost per resident $3,000 a month and that 2 of the facilities would close. For that reason, I ask for member support for the A50. Thank you, Mr. President.
Senator Hoffman on the A50.
Thank you, Mr. President. This is not Friendly, so I would respect a roll call, please.
Roll call requested, roll call granted. Any other discussion? Senator Dibble.
Thank you, Mr. President. Mr. President, members, I appreciate the points that Senator Frentz has made. I, however, Mr. President, will be voting no on the A50 amendment for a few reasons. The probably foremost reason, Mr. President, is that staffing is care. A resident who needs help getting out of a bed, using the restroom, bathing, receiving medication, preventing bed sores, avoiding falls, or responding to a medical emergency cannot receive that care if there aren't enough staff on hand to help them with those things. These are not luxuries. They're the most basic requirements of safety and dignity and human care. Mr. President, the staffing ratio didn't come out of the clear blue sky. It establishes a floor of 3.48 nursing hours per resident per day, including just less than an hour from a registered nurse and about two and a half hours from nurse's aide. It requires registered nurse coverage and clinical oversight appropriate to the level of acuity we are now routinely seeing in long-term care settings. This is substantially the same framework that was adopted by the Biden administration in 2024 as a national minimum staffing standard before that rule was later rescinded by the Trump administration after having received hundreds of millions of dollars in campaign support. The underlying research did not change, the politics changed, and the evidence remains overwhelming. Research from the Leonard Davis Institute at the University of Pennsylvania concluded that minimum staffing standards of this type can save 13,000 lives across our country. Research published in Health Affairs found that staffing mandates meaningfully increase staffing levels while not decreasing closure rates or undermining facility finances. In fact, the study found that additional labor costs were offset by improved revenues and stabilities, which, if you think about it for a moment, makes sense because that means that more people can come into those facilities, receive the care, and pay for the care that they need. The federal law already requires nursing homes to provide sufficient staffing to meet the needs of residents, and it states plainly that facilities must provide services necessary to attain or maintain the highest practicable physical, mental, and psychosocial well-being of residents, but it's not happening, hence these standards that are being requested to be put in place. Insufficient staffing leads to all of those problems I talked about earlier: falls, infections, pressure ulcers, dehydration, untreated conditions, delayed medications, avoidable hospitalizations, higher mortality. Members, we know that this is happening here in Minnesota. We have research that's been compiled and aggregated by our own Department of Health and reported to us by Elder Voices family advocates, and they show that fully 80 or 90% of the mortalities that are occurring track back to 2 factors. One is the for-profit ownership of these facilities that has led to reductions in staffing levels. Mr. President, this is a balanced and humane approach. The proposal allows for a hardship waiver for some facilities, especially in rural Minnesota, that allows them to describe the hardship and allows the commissioner to consider such factors as workforce availability, risk of closure, displacement of residents, and other factors. And waivers can be granted in those instances. So it is a balanced and measured approach that has got the focus not just of workers and facilities, but the residents who need this care. That is the focus that we should have. Thank you, Mr. President. I encourage a no vote.
Senator Rasmussen.
Thank you, Madam President. If we look at the last budget cycle, Senate Democrats have been tough on Minnesota's nursing homes. They put into place a 4% cap, and now with the language in the underlying bill, the proposal is that they would increase costs for nursing homes by hundreds of millions of dollars. And I think we can tell that this is a bad idea, and these nurse staffing ratios are a bad idea by simply reading the fiscal note. It is almost as if the agency is crying out and saying that this is an idea that we should not forward today. They talk about how, and I'm quoting from the fiscal note, between the additional requirements and the current struggle many facilities have in hiring and retaining nursing staff, MDH assumes that most of both types of settings, referring to assisted living and nursing homes, will request an exemption to the requirement at a rate of 90%. 90%. The agency is saying that 90% of Minnesota's nursing homes and assisted living facilities will not be able to comply with this law. And they further go on to estimate that they would anticipate almost 10,000 exemption requests per year. And so in order to handle those exemption requests in the fiscal note, there are an additional 74 FTEs for a total cost of $26.8 million per biennium. That's deeply troubling. That's going to result in nursing homes across the state closing. It'll result in fewer assisted living options for our seniors so that they can live next to their loved ones and stay in the communities that they have called home for decades. And Madam President, I do support and will be voting for Senator France's amendment, but it is incomplete. And so to address that, I'd like to offer the A75 as an amendment to the amendment.
The Secretary will report the amendment to the amendment. Senator Rasmussen, the number on the amendment?
Thank you, Madam President. It is the A75.
Secretary will report the A75 amendment.
Senator Rasmussen moves to amend the A50 amendment to Senate File Number 4476 as follows. This is the A75 amendment to the amendment.
Senator Rasmussen.
Thank you, Madam President. This amendment to the amendment would remove the rest of the mandates in Senator Dibble's bill on Minnesota nursing homes and assisted living facilities. While the Friends Amendment addresses some of the issues, I think we need to take a wholesale look at this proposal. And in fact, Madam President, there's already an informational hearing for this bill on Friday in the Senate Human Services Committee. So I think we should take out the entire proposal, look at it on a comprehensive basis. If half of it is not ready for prime time, I think we should look at it comprehensively. I'd ask for members' support.
Senator France.
Thank you, Mr. President, and thank you, Senator Rasmussen. I would ask members to oppose the A75 amendment. Members, what I am trying to remove is the staffing requirements. I have reviewed with the author of the bill the private equity portions, and am not suggesting, not suggesting that we change those in today. I'm also asking members to vote against the A75 because that has not been thoroughly vetted. And Madam President, again, requesting members vote no on the amendment to the amendment, and I would request a roll call, Madam President.
There will be a roll call. Senator McEwen.
Thank you, Madam President. And members, I would urge you to vote no on this amendment to the amendment. The reason we are having an informational hearing on Friday of these provisions of the bill that the senator from, I don't have it in front of me, it doesn't matter, Fergus Falls, thank you so much, is proposing we take out. We already had real hearings on these bills this biennium. We had last year hearings, Madam President, and we had them this year again in early March. The reason we are having the informational hearing on Friday is because in that time, a nursing home or assisted living facility in my district was sold from a nonprofit manager to a for-profit provider. Rents in that assisted living facility have gone up 60% in 4 months. There's a woman, a constituent of mine named Marilyn. She was paying $2,800 for her independent living apartment in November. Today, she is paying $4,300. She lives in the same apartment and receives no services. Now, when we had the hearing on these provisions in March, Madam President, I asked the lobbyists who came to lobby against these provisions, could we get agreement line by line? Maybe we could just agree on a few things. I explicitly asked, could they commit to passing a provision that would prohibit engaging in self-dealing? The answer was no. Come to find out, the assisted living facility in my district that raised the rents on seniors by 60% is doing just that. The owner of the management company also has an ownership stake in the property. How lovely for him to earn that money twice. In addition, the provisions in here just ensure that there is transparency for these seniors who are being raked over the coals as these nonprofit entities transition to for-profit. It is so important that we have them in here. The things that are happening to Minnesota seniors, frankly, should be illegal, and they would be very surprised to learn that it is not. Now, we should pass these provisions in this bill, and I thank the good senator from Minneapolis for bringing these provisions forward, for having the foresight to bring them forward last year, which we could have helped my constituents ahead of time, Madam President. They would not be dealing with this now if we had passed this into law, if they hadn't been taken out by industry at the last minute during conference committee. But this needs to stay in here. Seniors are being hurt. Seniors in my district and seniors in districts across the state. So I urge a no vote. Thank you.
Senator Abler.
Well, thank you, Madam President. It's a good discussion. I think I might be a co-author on most of those parts of the bill. And I do think, I agree with Senator McQuaid, that this is an issue that I'm sorry has not been yet addressed, and I'm really disappointed at some of the ways that these private equity people decide that they can just take everybody's money away. But Madam President, I've not been here as long as you, and I'm frankly going to miss having you up there. And it's good to see you there again. But we're 11 days away from the end. This bill is a really important bill to pass. I'm cheering the success that we got where I was working with some of the same people across the table to deal with when a person falls, can you actually not let them die into the corner, which is tragic. I just heard about another story about somebody that happened as well, actually up in my neck of the woods. And so there is sometimes ways we can get some of this done. But I just want to remind everybody, to my chagrin as well, that these several elements that we're talking about between the original Friends Amendment and these here stand virtually no chance to become law. And I was happy to support them getting this far. If I thought there was any chance that the other body would take these up and consider them in a serious way, I would be right on board. But I've just gotten pragmatic in my time here, Madam President. And the more we can make this piece of legislation closer to passage, the less we're going to actually have to worry about letting all this stuff fall on the cutting room floor come 11 days from now. And I want to remind people, we have till midnight on Sunday, a week from Sunday, to pass a bill. We don't have Monday, which happens to be my birthday. But so, Madam President, I actually am going to be voting to support both the Rasmussen Amendment and the Friends Amendment, not because I have changed my opinion about any of it, and I hope that the equity people who think it's a great idea to swallow up some of these properties that are themselves in fiscal harm will decide that we're not okay with that in Minnesota. And one last thing, Madam President, the money that it takes to buy the underlying part that Senator Friends is taking out has been snagged up because of a misunderstanding that I think Senator Hoffman and I were fully thinking when we did the negotiations last year on this same bill, that the 4% limit would not apply to raises approved by the nursing Standards Board or whatever it's called. And it turns out that the department is limiting those to 4%. And so they are just being constrained. There's hardly enough human beings, much less now the money that they don't have, which I think is actually a wrong interpretation by DHS of what we are led to believe. So if we can fix that, then the Senator Dibble's idea makes all the more sense to me, and I like the idea about quality care and adequacy. But Madam President, with regretfully, I'll be voting yes on both. Thank you.
Senator Greenhagen.
Well, thank you, Madam President. Yeah, I rise in support of the Rasmussen amendment to the amendment, and also Senator Friends' amendment. I'm supportive of that. You know, I have lost 2 nursing homes in the last several years in my district, and I stopped and visited quite a long time with the people in charge, and they just, you know, say there's just too many mandates that are driving up the cost. Now, I know Senator Dibble has his intention is good, but you know, when you pass a law that creates millions of dollars of costs at the state level, potentially according to the fiscal note, and more FTEs, how does that help the local nursing home? You know, I used to be in charge of negotiations, chief negotiator, when I was on the school board. And one of the things that came down was this ratio idea also, even in the school. And the Minnesota School Board Association said, do not negotiate away managerial rights. When you take one size fits all from the state, like ratios, and apply that all over the state, you're going to do more damage than good. According to my facilities, some of them are just barely hanging on now. And in fact, one of them got sold to a bigger outfit because they just couldn't make it anymore. So let's get this out of here. If we need to address some of these problems, let's do it in a way that works with local control rather than one size fits all. Again, I know the author of this provision that's in there that we're trying to remove means well, but you do more damage than good when you have one size fits all and send it down to the locals who get usurped on their control. Let's please care about the patients and the local control and support the amendment to amendment and Senator Friends' amendment. Thank you.
Senator Dibble.
Thank you, Madam President. Members, I thought I'd spend a moment to indicate why I support, of course, the provisions remaining and what they're about. Members, we're witnessing the rapid financialization of elder care. Increasingly, nursing homes and assisted living facilities are being acquired by these for-profit entities, often referred to as private equity firms, real estate investment trusts, layered corporate structures whose business model is often centered on maximizing short-term returns. And the evidence of its effects is impossible to ignore. A bipartisan United States Senate investigation led by Senator Chuck Grassley, a Republican from Iowa, and Senator Sheldon Whitehouse, a Democrat from Rhode Island, concluded that private equity ownership in healthcare has led to chronic understaffing, degraded care quality, health and safety violations, financial instability, and closures. That's the culprit, members. These closures are coming from these for-profit firms that are financializing these institutions, taking out loans, condominiumizing them, paying themselves off. The investigation found that investors extracted hundreds of millions of dollars while facilities suffer from reduced staffing and declining patient care. Senator Whitehouse stated plainly that private equity firms were putting profits over patients. Research shows that private equity ownership is associated with worsening CMS ratings, increased health code violations, higher hospitalization rates, and increased mortality. One study found mortality rates following private equity takeovers increase by 10%. Why does this happen? Because labor is the largest cost in long-term care, So investors seeking rapid returns, they go to staffing. That's the first thing they cut. Then they load the facilities with debt through leveraged buyouts. The real estate is sold off and leased back at a high cost. Related party transactions move money away from directed care into management fees and financial structures. So these public dollars intended for care become the mechanisms for extraction. Minnesota is not immune. 2025, Elder Voice Advocates reviewed MDH data that I mentioned earlier. They substantiated maltreatment investigations and found that 79% of those cases of abuse, neglect, and exploitation cases occurred in the for-profit facilities. The report identified 23 deaths directly attributable to these for-profit settings. 21 of the 23. They reported facilities operating with staffing levels as low as 1 worker for 50 residents. In another case, 1 worker for 70 residents. And members, we've seen the human cost in heartbreaking detail. I hope you saw the Star Tribune article of just a few days ago talking about Larry Thompson, a Minnesota veteran who suffocated after becoming trapped between his wheelchair and the wall while staff stood by unsure how to respond. And what did the penalty levied for that facility amount to? Only $5,000. So members, I'm trying hard to enact some provisions that say we don't normalize this in Minnesota. We cannot accept preventable suffering and death as simply the cost of doing business for our elders. These provisions do not prohibit for-profit ownership. They do not prohibit investment. What they do is establish guardrails. They require transparency about ownership and financial structures. That's the first part. It's just some transparency. Who you are, what is the corporate structure that you're proposing to come in and purchase these vital institutions of care. And then they prohibit harmful practices such as self-dealing and interfering with clinical judgment. And of course, we talked about the staffing levels. In short, they say if you're going to care for medically fragile Minnesotans, often with substantial public funding, members were talking about many of the folks who live in these facilities are being supported by our tax dollars. You do so responsibly, transparently, and safely because they're not simply facilities. These are homes. This is where people deserve to live in dignity, in safety, with care, and they're not simply business models that place profit and profit extraction ahead of human life. That's what's at stake if we were to take the A75 and take these measures out of the bill. So members, I would encourage a red vote on the Rasmussen amendment to the amendment.
Senator Hoffman.
Thank you, Madam President. You know how wonderful it is to say thank you, Madam President. The last time I got to say that to you was about 12 years ago when I stayed awake for 18 hours saying, Madam President, roll call. And if that hasn't been doing, let's there be a roll call here. Madam President, there's a couple of things that we need to look at. First of all, I'm against the Rasmussen Amendment and the French Amendment, right? I'll just make that very clear. And here's why. There's a couple of things that people are not addressing. On one hand, folks say, caps are good over here. Let's cap disability services. Let's cut waiver services. Yet we're not going to cap anything over here. Yet when we say it's time to invest in long-term care, we get oh no, no new taxes. Madam Chair, that's not the argument that I want here. What I want to do is this. There is 80% of the substantiated maltreatment that cases occurred in those for-profit facilities. One might say, well, they need that. But yet at the same time, Madam President, why aren't we really looking into the why that's happening, right? And I don't hear about the individuals that are receiving services. Our committee, we disagree a lot, but one thing we do agree on this committee is what's the right thing to do for the people that need the services the most, right? And so in that case, when you look at the substantiated cases occurred, that nearly 88% of substantiated cases occurred in assisted living. There is a difference. Assisted living facilities, people that choose to go to an assisted living facility, it is a pay-as-you-go system. Nursing homes are a federally entitled, mandated service that people can get because there are, what, 11, 15 mandated Medicaid services in the state of Minnesota? Nursing services is one of them. Nursing homes is one of them. So, Madam President, would Senator, or Mr. President, would Senator McEwen yield? Because I remember her bringing up something in our committee, and I just want to ask for clarification.
Members, we're on the amendment to the amendment, and I want to make sure that the question is to the amendment or relates to the amendment to the amendment. Senator McEwen, will you yield? She will yield. Senator Hoffman.
Unequivocally, Mr. President, does this actually work to what the conversation is at hand? Senator McEwen, if I understood you right, you were talking about the structure of those facilities and the substantiated or unsubstantiated cases. And could you please ask about that? Can I ask you about the structure of those facilities, please?
Senator McEwen, to the question.
Thank you, Mr. President, and I'm so glad that the good senator from Anoka asked me this question. This body has been very concerned about Medicaid fraud. And part of what Medicaid fraud could look like, Mr. President, because most people are the primary source of income in assisted living facilities and nursing homes, is Medicaid. It's the primary payer. And when there is deliberate obfuscation of the corporate structure of a nursing home, that is remarkably similar to the type of fraud, the Medicaid fraud, that we've been going after for many years. In particular, the good senator from Fergus Falls amendment deletes this line on 83.16. For-profit entities are prohibited from engaging in self-dealing. Mr. President, here are some of the examples of the ownership structures for-profit nursing homes. 10 family trusts, 5 LLCs, a group of unnamed employees, 3 named individuals that funnels into 3 more LLCs that funnels into another LLC and then goes to a final LLC owner. A corporate structure that moves money and hides ownership and engages in self-dealing, and then we have a bill right in front of us, Mr. President, that would prohibit engaging in self-dealing, and now we have an amendment to the amendment that proposes to take that out of the bill. Do we want to fight fraud or not? If we're actually serious, then we will not allow these corporate structures to suck money from taxpayers, to funnel into their LLC, to go into their corporation, to go to their shareholders, to go to their LLC, all while seniors get hurt and die. We should not be voting for this amendment to the amendment. For any reason, because of 83.16, the prohibition on engaging in self-dealing. The good senator from Fergus Falls' amendment to the amendment would delete that provision. It would continue to allow engaging in self-dealing. I have never in my entire life seen anyone so blatantly stand up and say, I would love for self-dealing to continue, and they're doing it with Medicaid dollars, with taxpayer dollars, and killing seniors. So I appreciate the good senator from Anoka's question, Mr. President, because it's very serious, and we should make sure that we are actually addressing the issue.
Senator Hoffman, you have the floor.
Thank you, Mr. President. I just request a vote no on this. Thank you.
Any other discussion on the amendment to the amendment? Senator Uckey.
Thank you, Mr. President. And I just want to stand and ask for support for both the amendment to the amendment and the underlying amendment. They are both needed drastically. Our nursing homes and assisted living providers are in a world of hurt, and what's being proposed would just basically push them over the edge. And the one thing that I just wanted to comment on, and some of it's been touched on, but that happened to be the fiscal note. I don't remember seeing in a fiscal note something like this before, where it says the new staffing ratios required in this bill will be challenging. It's spelled out, will be challenging for nursing homes and assisted livings to meet. if that isn't telling that it's going to be challenging, it's hard to do. Then it goes into talking about all the additional staff that the agency's going to need to handle all these requests for, they're just going to be having to file these requests because they're not going to be able to meet these requirements. That's just putting it in black and white, that what's being proposed in the bill is not workable. And if this was to go through, how many more facilities are we going to lose? Mandates cost providers and they cost services. Every time we mandate more on our providers, we're going to get less. And so, members, I just ask for your support, and I ask you to support both of these amendments, or the amendment and the amendment to the amendment, to save our nursing homes and our long-term assisted livings, all of our long-term care providers, because without them, we're going to be missing a big piece. Thank you, and ask for your support.
Any other discussions on the amendment to the amendment before we vote? And before we let Rasmussen, because he is the author of the amendment to the amendment. Seeing none, Senator Rasmussen.
Thank you, Mr. President. We get to see where Minnesota Democrats put their priorities when it comes to nursing homes. We see it in their budget bills. We see it in Governor Walz's budget proposals. And year after year, we see Minnesota Democrats proposing to cut funding to nursing homes, give them unworkable regulations, and result in closures of nursing homes and assisted living facilities across the state, leaving Minnesota seniors without options. When Senate Republicans had the opportunity, we leveraged support for other bills to put Minnesota seniors first, to save more than 40 nursing homes from closing across the state. And that's why I'm bringing forward this amendment. It is pulling out language that will lead to closures, that will lead to fewer options for Minnesota seniors. This has unnecessary Attorney General enforcement. It has rent control. It has regulations that will leave seniors without options if a nursing home closes in a community. These new regulations will have a chilling effect on more options for seniors. And I also want to respond that this proposal, this language, does not come from the Minnesota Department of Health. It does not come from the regulator that has spotted these types of issues. And by the way, nursing homes their cost reports are very closely audited. We have regulations that aren't going to help Minnesota seniors. They're going to result in higher costs to those seniors and fewer options. I would ask for members to vote yes on this, to put Minnesota seniors first, to make sure that we have options in communities all over the state for our seniors to age. Thank you.
The Secretary will take the roll on the amendment to the amendment. A roll call was requested and a roll call granted. Members, please vote. Senator Herr, for those voting pursuant to Rule 40.7.
Mr. President, Senator Port vote no.
Senator Port votes no.
Senator Murphy votes no.
Senator Murphy votes no.
Senator Marty votes no.
Senator Marty votes no.
Senator Wicklund votes no.
Senator Wicklund votes no. Senator Herr, do you have a report for Senator Carlson?
Still have Wi-Fi delayed here.
Okay. I'll go to, I believe that Senator Rasmussen will report, and I'll wait until he's ready.
Mr. President.
Senator Herr.
Senator Carlson votes no.
Senator Carlson votes no. Senator Rasmussen, for those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Lang votes aye.
Senator Lang votes aye.
Senator Johnson votes aye.
Senator Johnson votes aye.
And thank you, Mr. President. Senator Liskey votes aye.
And Senator Liskey votes aye. All members having voted who desires to vote, the Secretary will close the roll. There being 33 ayes and 34 nays, the amendment to the amendment is not adopted. Now, members, we're back on the A50 Friends Amendment. Any additional discussion? Senator Hochschild.
Thank you, Mr. President. I want to thank Senator Frentz for bringing the underlying amendment. I have a lot of nursing homes and assisted living facilities in my district, particularly in very rural communities where there aren't that many people. And so they face very unique challenges. And I talk to these administrators, I visit the sites, I do tours, I talk to the residents on a regular basis because they're a significant part of my constituency. I have an aging population in my district in northern Minnesota, and our assisted living and nursing homes matter a lot. People want to retire in dignity in their hometowns. They want to live where their families live. And having those family nearby, having the ability for your loved one, your spouse, your kids, your family to visit you is a critical component to growing older, to being in these facilities and not feeling lonely. And if we move forward with staffing mandates that don't work for our rural nursing home and assisted living facilities, I worry about the challenges that will face many of the nursing home and assisted living facilities in my district that will require those facilities to close and those seniors to move further and further away from their home communities. And that in and of itself would create additional challenges as they grow older. And we know that these nursing facilities in these rural communities face additional unique challenges. Some of my communities with nursing homes have 1,000 people, 500 people in the entire town. It's not that these facilities don't want more staff. I mean, I talk to the administrators all of the time, and they are begging for people to come work at these facilities. They're begging for more staff to help support them so that they can open up more beds, so that they can expand their ability to allow seniors to retire in dignity in their facilities. But that's just not an easy option for these facilities when there's only so much workforce available in their communities. I also think there's an additional challenge when it comes to the regulatory burden of the hardship waiver that is in the underlying bill. Certainly, I understand there would be that option, but talking to these administrators and staff in these nursing homes, they are already stretched so thin that adding additional requirements, additional regulatory burdens on them just takes them further away from being at the bedside with these seniors and away from actually doing the care that they need to be doing, and instead filling out waivers that frankly we have just pushed down on them because we know that they need a waiver in the first place. I want to say thank you to Senator Hoffman, the chief author of this bill, because he has been a champion for the critical nursing home funding that I have really been pushing for, that go to some of the hardest reaching nursing home and assisted living facilities in our state. But if we're going to do additional mandates, we should look at funding like that program and others when considering these types of mandates. That would be my hope, is that as we consider these in the future, we would look at additional funding for critical access nursing home funding. We'd look at additional funding for our nursing homes so that they can find ways to incentivize staff and bring on more of that workforce that's needed. I also want to thank Senator Dibble for his thoughtfulness on this issue, really standing up and looking out for people, putting people first. He immediately got to work when some of us in the caucus came to him with concerns, particularly from Greater Minnesota, about ideas that we could work on together that would help us reach these goals, but also address some of the concerns. For example, less burdensome waivers, workforce incentives, longer phase-in of these mandates, figuring out reduced penalties so that nursing homes aren't forced to reduce staff or close because of those burdens, and some flexibility based on acuity. These are the types of in-depth conversations and nuance that comes with these challenging issues, and my hope is if this amendment passes, that we can continue working with Senator Dibble, Senator Hoffman, and those of us that care deeply about this amendment so that we can find a workable solution. And with that, Mr. President, I encourage a green vote. Thank you.
Senator Abler. Senator Housley. Members, just in the future, please don't keep pointing and so on and so forth. That would be helpful because I can't always hear, and I want to make sure I'm being respectful of everyone. Senator Housley, that's not because of you. I'm just saying that in general, because when people do this, this is what happens, Senator Housley. Okay, thank you. Senator Housley.
Thank you, Mr. President. Brings me back to my cheerleading days. I, too, want folks to support the Friends Amendment. It's critical for the future of our long-term care facilities in Minnesota, especially in our rural communities. Right now, we are facing a crisis, and the provisions that are being struck from the bill will make it much better because it will take out the mandates on our staffing ratios. And if they are allowed to continue, it will only deepen our crisis. These sections that Senator Frentz is proposing to remove are quite simply unworkable. They jeopardize access to care for our most vulnerable citizens, and the stark reality is that we don't have enough nurses to meet these ratios. These new staffing ratio mandates will not magically create more nurses. They'll only create impossible burdens. I know a few years ago I had to search for a long-term care facility for some of my loved ones, and I know others in this chamber have talked to me about searching for a place for their parents to live, and it's difficult. It's really, really hard to find a place for them to live, and then one that's also affordable. But this Article 4 with Section 2 through 6 in it is going to make it even tougher. They're going to drive up the cost for our facilities, which will inevitably be passed down to the families, making long-term care even that much more unaffordable. And for many facilities, especially the smaller ones in rural Minnesota, they serve as lifelines to the community. These mandates will force them to close their doors. And we're going to see fewer options, longer waiting lines, and more difficult choices for Minnesota families. And I know the numbers have been pointed out here a few times on the floor, but the new mandates, the new nursing staffing mandates, is going to cost a staggering $26.8 million. That requires 74 new FTEs to approve the waivers that 90% of our facilities will be applying for. So we have new FTEs costing $26.8 million for these facilities who cannot afford the new mandates. And I don't know if your long-term care facility has spoken to you, but they passed out a sheet to how much this will cost each of their long-term care facilities in their district, and it's in the millions. These mandates will cost each of our long-term care, on average, it's $3.5 million per long-term care facility in each of our districts. This isn't just about the numbers, it's about people. It's about our parents, our grandparents, our neighbors, and our friends. It's about ensuring that they have a place to live, a caring place, accessible place to live when they need it most. By imposing these unworkable mandates, we are not improving care. We are actively reducing the number of care facilities that will be able to remain open. We are creating a system where the very people that we aim to protect will have fewer options and face greater financial hardship. I encourage a green vote on the Friends Amendment. Thank you.
Senator McEwen.
Thank you, Mr. President. I want to help some of my colleagues out. I'm going to urge a no vote on the amendment, and we don't have to guess about how safe standards in nursing will go in our nursing homes. There was a longitudinal study done from 2010 to 2023 on 6,849 nursing homes operating across 22 states. Here was the outcome. Facilities' labor expenses rose by about $273,000 per facility, and their net margin, their net patient revenue, was $546,000. So yes, Mr. President, absolutely, it will cost money to staff appropriately. And I want to put a little hyphen here, Mr. President, to staff a nursing home appropriately so that residents are safe. I really am appalled to hear we couldn't possibly keep people safe in nursing homes because it'll cost money. That's kind of the opposite of what we want to do for our seniors. But here's the thing, Mr. President. When residents have access to appropriate care in real time, it reduces acuity, it reduces emergencies, it reduces staff burnout, which reduces turnover, which reduces training costs. So you can see why, on average, there was a net revenue increase to the facilities in places that had minimum nursing staff ratios or standards. So yes, of course, it'll cost money if we hire more people at the IRS, but we'll get more money at taking back tax money from white-collar criminals. So I just don't understand this argument that having more people to keep our residents safe, to keep healthcare emergencies lower, to keep more people alive longer or living more independently, that's not bad, that is good. It is why the rules should go into place federally, and it's why we should have it here in the state. The last thing I want to say, Mr. President, is that one of the central issues that you hear from families or residents themselves in nursing facilities is neglect. And so we cannot solve that problem if we say what we have now is good enough. I don't think anybody would say right now is good enough. I just had a town hall in my district 3 weeks ago, and I had some of the most basic questions. Why can't someone help my mom when she just needs this one little thing? And the answer is because nobody's there. Safe staffing and nursing standard ratios are so crucial and important. And just because the nursing home lobby had millions of dollars to give to Trump to repeal the safe standards federally doesn't mean we should do that here in Minnesota. We should keep Minnesota seniors safe and vote no on this amendment.
Senator Putnam.
Thank you, Mr. President and members. You know, I have a friend named John. He was my student at St. John's 800 million years ago. Super nice guy. And back in the day, I supervised his internship in long-term care, and he's still in that industry now. He's an administrator. And he reached out to me this morning, and we talked back and forth a little bit. And he wants to hire more people. He wants to have a better ratio between staff and the folks who need their help. But I'm conflicted on this amendment, partially because of what he told me next, which was that those workers don't exist. In our community, he wants to have more people there doing this work, but they just don't exist. He can't hire people now because people aren't prepared for this. So one thing that I would have liked to see in this bill, or in this possibility, is some additional resources towards workforce development. So if we're going to require people to have a certain ratio, we have to make sure that those people are trained well enough and they exist to do that job. And right now in greater Minnesota, in my community, the people aren't there. And that's a significant problem. I appreciate Senator Dibble's work on this. I think it's really good stuff. And also that there are hardship exclusions for issues like not being able to find the labor. I think that's really great. But when it comes down to it, if we're not also putting in the work to developing the talent to do these jobs, we're not really doing what we need to do to help people. Mr. President, as I mentioned before, I'm conflicted, not entirely sure how I'm going to vote on the amendment, but I will say that we need to also invest in workforce development so that we have people in industries of care who can actually do this work.
Senator Abler.
Thanks, Mr. President. Apologize for the confusion there. Just Senator Housey had not spoken. I was trying to be expeditious and not take up any extra time because maybe she would have said something I didn't have to say. So thank you for your consideration. I apologize for the confusion. So, Mr. President, is it appropriate in the floor of the Senate to say, really? Tell me you're kidding. Can we say that? Is that okay? Okay, thanks. I'm interested in the discussion here. And, you know, there's a lot of things I wish could be, Mr. President. I was never good at athletics. I always wanted to at least be average. And I was never even that good. But it would have been nice if I could have been chosen before, like, the last couple of players. And I wish that there was a way to have everything go like I wish it could be in the long-term care arena. Mr. President, do you know we're short 50,000 workers in this arena? 50,000. And you're not in this topic area, but you probably believe that's a lot of people. And it's even getting worse. COVID didn't help. Paying people to not go into work didn't help because all these people are marginal. They get $20 an hour maybe if they're lucky. And it's really a problem. And so I'm just kind of shocked about the concern about suddenly we need to make sure there's enough people there. And just, you know, Mr. President, if there's anybody who's wanted more people, more nurses at the bedside, have a safe place to work, more staff supporting the rank and file labor people who work as CNAs and other jobs in these places, it's been me. Mr. President, you were not present a couple days ago when we took up the Senator Wilkins' bill about provider compliance and fraud and so on. And as part of that bill, there was an element in there, and they did some reductions to save some money for a reason I don't know, but there was a part for the nursing homes in there, Mr. President, and there were two pieces. One had to do with not paying for the insurance, the increased insurance costs, and one had to do with quality scores. Ironically, the insurance costs that would have been in that were carried in the bill as reductions would have actually affected the SEIU and the staff, nurses at the nursing homes who are getting the health insurance costs that are going up. And so if it's over $15,000, then they weren't going to get any money for it. And that would have saved $20 million to the state. It would have caused a great problem for those individuals who are used to getting good insurance. Part of the challenge of drawing more of this up to 50,000 people is to give them decent wages and stable benefits. And that was an interesting element in the bill. And Mr. President, there's also something else called quality score. Quality. And so the better your quality, the more you might get paid, and there's a way to do a reform. And if you, well, it's about why this, you keep making these hand signals. I get it, Mr. President. But some of this just is important to understand the grand picture. And so the sum as that was $80 million that would be cut. And when I objected to that, which would have actually made it easier to handle the ratios in the bill, Mr. President, that we're talking about, I was rebuffed. And I was rebuffed actually at volume, and we chatted quite a while, and the good senator from Apple Valley was like, oh, we can't be doing that. So let's demand ratios and take away $100 million from the nursing homes. I don't understand, Mr. President. And it just is irrational. And so I don't know, just, you know, sometimes we agree on things, sometimes we don't. And I don't spend a lot of time talking about who's doing what. But it was the majority party that took away, that's still in the bill, wants to take away $100 million from nursing homes, which is going to cause nothing but harm and make it less able to even keep the staff they have, much less maintain these ratios. Mr. President, I'm a co-author on the ratio bill. I think we want to assure quality. I think we want to make sure. But if you think that by leaving this in the bill, there's one more chance to get one more human being in a room to take care of anybody, you're just, don't you wish it could be true? This is not going to become law, nor the previous parts that are in the bill. And it's good we can make our point, as many bills are going these days, Mr. President, but it is time now to get on to what we're really going to get done and make sure that we can truly help nursing homes, truly help these good workers to keep working and get away from ridiculous cuts like what's in Senate File 4022. And so maybe the other side of the aisle can come to reason and realize you can't get better quality by cutting their money. And so, just for practicality, I hate to be voting to remove this, but I agree with Senator Frentz. Thank you.
Senator Rasmussen.
Thank you, Mr. President. And I want to respond to some comments from the senator from Apple Valley on the idea of minimum staffing standards for long-term care facilities. And so I'm just going to bring up some comments that former DHS Commissioner Jody Harpstead had on Joe Biden's proposed minimum staffing standards for long-term care facilities. This is from a letter that Commissioner Harpstead wrote on November 3rd of 2023. She said, the proposed rules remedies are overly general and prescriptive in a way that has the potential to harm various stakeholders, including residents and families. She goes on to say the proposed rules rely on labor force participation that may not be possible for many facilities. And later on in the letter, Mr. President, Commissioner Harpstead states, it appears to prioritize a care input staff hours over outputs such as better care or higher resident satisfaction. So, Mr. President, the Walz administration opposed the overly prescriptive staff requirements that President Biden proposed at the federal level and that we have Senate Democrats proposing in this underlying bill. And so I'll be supporting the amendment. It tries to mitigate further damage that Senate Democrats have done to the long-term care and to the seniors who rely on it. But I just wanted to make sure that we knew that folks that are looking at this policy say that it's unworkable, it's going to harm families, it's going to harm patients, and it's focused on inputs and not outcomes.
Senator Westlin.
I promise to be brief, and I will. I keep hearing about mandates and staffing ratios, but I want to bring this back to people. Because what we're talking about is keeping residents safe, some of whom may be on waivers and receive some sort of assistance paying for their care, but a lot of people who pay good money for the care that they're receiving. My daughter-in-law's grandfather had a fall in a nursing home, and he died as a result of it. And there was a finding of maltreatment, and they probably paid a small fine. But that's what we're talking about here. We're talking about having staffing levels that are appropriate to keep people safe. We're talking about making sure that people have appropriate training. And we are talking about holding people accountable for that. This is a very difficult problem. I get that. But finger pointing isn't helping it. Staffing levels are problematic because there's not enough staff because we don't pay them enough. There's a lot of things involved here. But let's not forget we're talking about people and caring for people.
Members, let's remember that we're not supposed to look at another member and glare and stare them down. You're supposed to look at the president, okay? All right, Senator Frentz.
Thank you, Mr. President. And members, the reason that I moved to Minnesota was because I love the life and I love the people and I love the area of Mankato. Next month, we'll welcome the 8th generation of my family. And what used to happen is that grandfathers and grandmothers would live with their own family. Mr. President, what I'm asking here is, given that we've morphed, that we've changed to a care facility where people in assisted living or nursing homes are taken care of by someone else, if that's our choice, let's remember what's possible. There are no nurses in southern Minnesota to staff these. There are no nurses waiting to go work. There are the facilities themselves, and they are going out of business. Mr. President, you may remember the debates 3 years ago about nursing homes closing. Anyone in this chamber knows that small, rural nursing homes and assisted living facilities close. The reason they close is they cannot be sold and they cannot make a profit. And sometimes in this chamber, we act like the people who invest their own money in a business have an unlimited amount. They don't. When I informed the people in my district who ran these facilities that the staffing ratios were a topic of conversation, one of them laughed. He said, where are those people going to come from? And why is it you want me to stay in this business if you're going to tell me what the best way to run it is? The customers are the families. And I, for one, hear some comments about capitalism in this chamber, and I'm going to leave that debate because we will never get off the floor. But we have to provide a level playing field for those that own businesses in order to make a profit, or we won't have those businesses anymore, Mr. President. We won't have the revenue that comes from them, we won't have the jobs, and we won't have the kind of care that we want for the people who we love the most. Members, I'm asking you to strike the staffing ratios. I care just as much about those families and the residents. I care just as much about the men and women that do that work. But the better approach here is to say that if the state wants to mandate staffing, as members have suggested, we'll then provide the resources to do so. Don't simply jam it down the throat of the nursing home and assisted living. And for those that don't distinguish, I'll distinguish it for you. In Minnesota, nursing home facilities are owned 1% by private equity. And I do hear the evils of private equity, and I do look forward to working with members on those. 1%, Mr. President. And for that, we are talking about staffing ratios for people that simply don't exist. Members, remember, the unemployment level in Minnesota is lower than the national average. There aren't a bunch of people sitting around saying, I wish I could get a job. And if you pull the capitalist system out of orbit too far, you're going to find a negative reaction, as we have seen with other controls where government says, hey, we should tweak this, turn this dial. Mr. President, thank you for the time. Members, I ask you to vote yes on the A50 and send a common sense message to rural Minnesota that we will stand beside assisted living facility owners and nursing home operators and keep them in business. Thank you.
Members, just so that you know, I thought Senator Friends was going to say something else. I didn't know he was doing his closing because I had promised Senator Nelson the opportunity to speak. And you know our custom is to always have the author last. But we're going to diverge just for a second. Senator Nelson, I promised you the opportunity to speak, and we will vote.
Thank you, Mr. President. I do not want to step on Senator Friends's final comments. I have to say I agreed with them all. But I would be remiss if I did not get to speak here today. Many of you will recall in 2017, just about a week from today, my dad was in a long-term care facility at that time. And we were going through personally the many things that we heard on the floor here. And I will just identify very briefly a few of them. When we talk about staffing ratios, members, let me just say, there is nothing that is exactly the same with every patient, every resident, every day. Our bodies are different. Our environments are different. Our reactions are different. And to think that there needs to be the same ratio every day is not understanding the volatility in a person's needs in a particular long-term care setting. So there is that problem. And then, of course, there is the workforce shortage. My colleagues here have spoken about it greatly. The part of Minnesota that I live in, particularly southeast Minnesota, when it comes to nursing of any type, of any avenue, there is a massive shortage. I have constituents who have to drive hours to go to visit their loved one who lives right near them, but the nursing home is 2 hours away. And that is not fair at the end of someone's life, that we are making it so that their nursing home, the place that they can go, is so many hours away because we have failed to do what we need to do regarding our long-term care facilities. And then, of course, I would be remiss if we didn't talk about the cost. The cost of long-term care is sometimes just overwhelming. And that's why the majority of patients, of residents, are now on Medicaid. In my father's nursing home, we found that there were 7 floors of residents, and he was one of less than 10 that were private pay patients. So most of the patients, most of the residents, are Medicaid patients. And those reimbursement rates don't increase just because we increase the cost with staffing ratios. So I strongly support the Friends Amendment. We need to be respectful and honest as we look at how we care for those loved ones who came before us and forged the paths before us. Thank you.
The Secretary take the roll on the A50 amendment. Members, please vote. Senator Herr, for those voting pursuant to Rule 40.7. And members, we're in the middle of a voting. Senator Friends, why do you always seem to keep violating this rule, sir? Stop violating the rule. Thank you. No, he always wants to point to someone else, and he's always engaged in these conversations. Senator Herr, for those voting pursuant to Rule 40.7.
Thank you, President Champion. Senator Carlson votes no.
Senator Carlson votes no.
Senator Ports votes no.
Senator Port votes no.
Senator Murphy votes no.
Senator Murphy votes no.
And Senator Wicklund votes no.
Senator Wicklund votes no.
Thank you.
Senator Jasinski, oh, did you have another one, Senator Herr? I just want to make sure I didn't cut you off. All right, Senator Jasinski, for those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Barr votes aye.
Senator Barr votes aye.
Senator Johnson votes aye.
Senator Johnson votes aye.
Senator Lang votes aye.
Senator Lang votes aye.
And thank you, Mr. President. Senator Liskey votes aye.
Senator Liskey votes aye. Members vote, or I'm going to close the roll. All members having voted, who desires to vote, the Secretary will close the roll. There being 38 ayes and 29 nays, the 850 Friends Amendment is adopted. Members, I will now recognize for the next amendment, Senator Housley. Take you off the list? All right. Senator Pratt.
Thank you, Mr. President. In 2025, the nursing home licensure surcharge was raised from $620 to $2,815, a 350% increase. Then we raised that 2815, that 350% increase to $5,900, another 110% increase. These surcharges are passed to nursing home patients through their providers. Then we also increased a provider surcharge from $8.86 per patient to $19.02 per patient, a 115% increase. Mr. President, neither of these fees were approved by the Center of Medicare and Medicaid, or the Center for Medicare and Medicaid Services. And now we have many private pay patients are stating they're paying these increased fees. We have a long-standing principle in Minnesota of assuring that private pay patients pay the same as our medical assistant patients. And that's just not happening. It's outrageous. This outrageous increase pushes more seniors into MA sooner by depleting their savings. So, Mr. President, I'd like to offer the A45 amendment.
Senator Pratt offers the A45 amendment. The Secretary will report the amendment.
Senator Pratt moves to amend Senate File Number 4476 as follows. Page 16 after line 14, insert. This is the A45 amendment.
Senator Pratt.
Thank you, Mr. President. Mr. President, since CMS has not approved these increases, we will roll back and we will roll back the amounts previous to when they were passed in 2025. The last amounts that were approved by CMS. The federal government is forcing us to roll those back on October 1st, and rather than keep those in place for another 5 months and charging our seniors more than they need to be charged over 5 months, we should roll them back now.
Mr. President, the question to members on these fees, on this tax that is being rolled down to them, these surcharges that we have called the granny tax. The question is, do you stand with nursing home and patients, or do you stand with a fraud-riddled agency? Members, I encourage you to vote yes.
Senator Hoffman.
Mr. President, will Senator Pratt yield?
Senator Pratt will yield. Senator Hoffman.
I was going to ask him a question, Mr. President, about the Fair Debt Collections and Practices Act, Section 805, but that was about 13 years ago. But I will ask him this question. That when you delay the federal compliance piece, can you help me understand what you mean by that? Because I think, if I understand you right, that this would be a friendly amendment.
Senator Pratt.
Thank you, Mr. President. Mr. President and Senator Hoffman, we are not delaying the compliance. We're just buying a year's worth of gap with this change.
Senator Hoffman.
Thank you, Mr. President. I just need to convey with a financial person, our nonpartisan, to make sure it fits in. Part of me saying it's not friendly, but I will probably say it is friendly, so hold on. Got some bumper music, Mr. President?
Senator Hoffman.
Mr. President, thank you. After concurring, I think I do want to see, I want to yield to Senator McEwen, if that would be possible. Can I do that during this debate? Because I want to make this work, so.
I recognize Senator McEwen.
Thank you, Mr. President. I would offer an oral amendment to the amendment.
Please state your amendment.
Thank you, Mr. President. I would, on the amendment, delete line 2.11. And, Mr. President, I would also delete line 2.12 and line 2.13 of the amendment.
Secretary will report the McEwen oral amendment.
Senator McEwen moves to amend the A45 amendment as follows on page 2, delete lines 11 through 13.
Senator Hoffman.
Thank you, Mr. Chair. And with that, if that is acceptable, then I would take the Pratt amendment as a friendly amendment, and that's it. Do it. We need a roll call on the oral amendment, please.
Roll call granted on the amendment to the amendment McEwen. Senator Abler.
Well, since we're waiting for bumper music, could somebody just explain what that amendment does? Senator McEwen, can you say what that, maybe you like the amendment, you want it to work, takes away money, besides this, here's some date changes? Thank you.
Senator McEwen will yield. Senator McEwen.
Thank you, Mr. President, and thank you to the good senator. Thank you, from Anoka. Oh, I was referring to you earlier. My apologies to the senator from Anoka. Mr. President, this would delete from the amendment the change in the effective dates for the provisions that would help provide Minnesota seniors who are now living in for-profit facilities from having their rents unnecessarily jacked up and their fees. In particular, I'll point members to line 65.20. This is talking about change of ownership contracts. On 63.13, we are looking at approving or disapproving increases charged for housing. And Mr. President, this is a very important amendment to me because right now in my district, seniors who are living at the Rosemont are experiencing exactly what this bill could have prevented. I brought up earlier a woman named Marilyn. She lives in independent living. When she moved in November, her rent was $2,800. Today, her rent is $4,300. For the same apartment in the same facility within 4 months, she has had her rent increase exponentially. This bill would have prohibited that unless there was a necessary reason for that rent hike. And my residents cannot wait until 2027 for this bill to go into effect. We needed it last year when these provisions were in conference committee report, but since we didn't get it then, Mr. President, we absolutely need it now. That's what the amendment does.
Further comments, Senator Abler.
Well, Mr. President, it seems like it's a marriage of the minds, and so I think we should vote yes on both. Thank you.
Senator Pratt. Senator Rasmussen.
Thank you, Mr. President. Would Senator Mayquade yield for a question?
Senator Mayquade, will you yield? Senator Mayquade will yield. Senator Rasmussen.
Thank you, Mr. President. Thank you, Senator Mayquade. Senator Mayquade, if your amendment to the amendment is adopted, do you see any issues with the underlying amendment as amended? Will you be bringing any points of order to try to keep this amendment from going to a vote?
Senator Mayquade.
Thank you, Mr. President. And part of my hesitation in agreeing to yield is because I was listening to nonpartisan fiscal staff explain what the underlying amendment does. I don't know at the moment. I would leave that to Chair Hoffman. But if it puts it out of balance, I wouldn't support it. So I'll leave it at that. Thank you.
Senator Pratt.
Thank you, Mr. President. Would Senator Hoffman yield?
Senator Hoffman will yield. Senator Pratt.
Thank you, Mr. President. Senator Hoffman, if we add these new effective dates, or if we stripped out these effective dates, will that, and we've balanced this amendment to comply with Rule 7.4, would this put us out of balance with Rule 7.4?
Senator Hoffman.
Mr. President, yeah, that's why the conversation was over here. I went over and I went conferring, and so what we'll probably end up doing is I think the good senator from Apple Valley will probably withdraw her amendment, and then we'll go ahead and add yours. But I had a hard time, Mr. President, and I'm not supposed to be looking at Senator Pratt, but you know, I'm looking through you, Mr. President. That 2027, I'm not comfortable with it. I understand what we're trying to do. We're balancing it. I mean, if this, I would not be in agreement with the Pratt amendment. But having said that, yield to Senator. Will Senator Mayquade yield, Mr. President?
Senator Pratt has the floor. Senator Pratt.
Mr. President, I yield the floor.
Senator Mayquade.
Thank you, Mr. President. I would withdraw my oral amendment to the amendment.
Senator Mayquade withdraws the amendment to the amendment. We are on the underlying A45 Pratt amendment. Further discussion. Senator Hoffman.
Mr. President and members, I would respectfully ask for a no vote.
Further discussion on the A45. Senator Mayquade.
Thank you, Mr. President. I would ask for a roll call.
Roll call granted. Senator Abler.
Well, thank you, Mr. President. And what I understand this is trying to do, and I actually support what Senator Mayquade was trying to do to protect the assisted living people from, frankly, predators. But this is trying to protect people in nursing homes just from math. There are people who have reported that their nursing home rates have gone up like double as a result of what happened in the last budget, which was not in our awareness as we were putting that together. At least I was not aware of what might happen. And so this, we do not want to put seniors out of their homes. And so this is not a vote for anything to do with assisted living. This is about nursing home people that are private pay being able to afford stay in their nursing homes. And so this bill is going to go across the street. This actually has a chance to get worked out. The other side, I mean, I'm from there, so I kind of, they're so lost cause now from when I left there, Mr. President. But I know that there's some sensible people there who could look at this element and have it make sense so that the grannies who were suddenly victims of a huge increase that they did not see, which in at least one case is double their private pay rent. So, Mr. President, this is not a vote about something ethereal that might happen. This is happening. The vote on here is this will help stop exorbitant increases from people who didn't even know it was coming. And so that's what a yes is. A yes, if it's imperfect, we can get that sorted out. But this is a question, a matter that's really important. And so please just don't blindly follow somebody who says, vote no. Vote yes. Actually, use the active part of your brain and go like, I do think I want to keep people in my district from being abused just by math. So please vote yes. Thank you, Mr. Chair.
Senator Rasmussen.
Thank you, Mr. President, and thank you, Senator Pratt, for bringing this amendment to put Minnesota seniors first. If you vote in favor of this amendment, Mr. President, members, you are voting to keep money in Minnesota seniors' pockets while they are in a nursing home. If you vote against this amendment, you are supporting the granny tax. You're supporting taking money out of Minnesotans' pockets when they're on private pay in a nursing home. And unfortunately, we saw Senate Democrats in the last budget put a tax on Minnesota seniors in nursing homes of $137 million. That made nursing homes more expensive for Minnesota seniors. That impoverished seniors quicker so that they had to come on to medical assistance in our state. And the Pratt Amendment will prioritize those seniors and make sure that we're directing resources to them and not continuing to tax them to fund other projects. And so I would encourage members to support this amendment.
Final discussion, further discussion. Senator Pratt.
Thank you, Mr. President. Mr. President, a year ago I lost my dad. He had Alzheimer's. I couldn't take care of him at home. Found a great place for him. And I have watched the people that he lived with in that facility. I've watched their rents increase. They increased when we passed paid family and medical leave. Now, I can tell you, because I was on the board of this facility for a while, that we took care of our employees. We did that pay as you go. But instead, we decided that we needed to take that money out, send it to the state, and create a cash flow problem. So they increased rents. Earn sick and save time, increased rents. All the different labor mandates we put on have increased rents. And then we turned and we increased the nursing home licensure surcharge 350% for 1 year, and then increased it another 110% the next year. And oh, by the way, we kicked up the provider surcharge 115%. Mr. President, we are taxing and feeing our seniors out of their savings. We are pushing them to medical assistance faster. And we know on October 1st that these fees will revert back to what is in this amendment. And we are saying our appetite for taxes and fees is so great that we can't give our seniors a 5-month break. Mr. President, I think that's extremely sad. I think it's extremely sad that this body would not put its seniors first. And I encourage a yes vote.
The Secretary will take the roll on the A45 Pratt Amendment. Senator Herr for those voting remotely.
Thank you, Mr. President. Senator Carlson votes no.
Senator Carlson votes no.
Senator Frantz votes no.
Senator Frantz votes no.
Senator Port votes no.
Senator Port votes no.
Senator Murphy votes no.
Senator Murphy votes no.
Senator Marty votes no.
Senator Marty votes no.
Senator Wickland votes no.
Senator Wickland votes no.
Senator Champion votes no.
Senator Champion votes no.
And Senator Latz votes no.
Senator Latz votes no. Senator Jasinski.
Thank you, Mr. President. Senator Barr votes aye.
Senator Barr votes aye.
Senator Lang votes aye.
Senator Lang votes aye.
Senator Liskey votes aye.
Senator Liskey votes aye.
And thank you, Mr. President. Senator Weber votes aye.
Senator Weber votes aye. Senator Herr.
Mr. President, Senator Fateh votes no.
Senator Fateh votes no. All of senators having voted with the desire to vote, the secretary will close the roll, there being 33 aye votes and 34 nay votes. The A45 is not adopted. Further amendments, Senator Liskey. Senator Abler.
Thanks, Mr. President. I think the more people watch what we do, the more like, wow, that was interesting. So I think it's time for something that's, in the words of Monty Python, something completely different. Mr. President, I'll move the A46.
Senator Abler moves the A46 amendment. The Secretary will report the amendment.
Senator Abler moves to amend Senate File Number 4476 as follows. Page 41, delete Section 3 and insert. This is the A46 amendment.
Senator Abler.
Well, thank you, Mr. President. In addition to being a different number, it's a whole different topic. And so some of this has to do with licensure and the speed of getting credentialing. I'm actually going to read a sentence, but I don't usually do just to get it straight because it's a little even confusing to me. But this will allow residential substance use providers that are currently receiving room and board payments prior to May 1st, 2025 and have submitted a substantially complete application and required report for initial licensure to continue to receive those room and board payments until final action is taken on the new license. And we meant to offer it earlier in the committee and we did not, so here it is now. Thank you.
Senator Hoffman.
Thank you, Mr. President. I think the good senator from Anoka needs to explain in detail to the whole body for the next 20 hours about what 254B.04 subdivision 2 will mean in reference to the rest of the bill. And instead of that, it's a friendly amendment. Vote yes.
Further discussion on the A46. All those in favor of the A46 say aye. Aye. Opposed? Nay. The amendment is adopted. Senator Abler.
Thank you, Mr. President. I have another different number to offer, the 848.
Senator Abler offers the A48 amendment. The Secretary will report the amendment.
Senator Abler moves to amend Senate File Number 4476 as follows. Page 87 after line 25, insert. This is the A48 amendment.
Senator Abler.
And thank you, Mr. President. I'd like to divide the amendment, and I'm not intending to offer the part I'm going to divide away. And that is everything, so everything up to line 3.13 is what I'd like to divide it and then vote on that first. And then everything 3.14 would be another discussion, which we're not going to have.
Secretary will report the division.
Senator Abler requests to divide the A48 amendment in two parts. The first part is page 1, line 1. Excuse me, page 1, line 2 through line 13, through page 3, line 13. The second portion of the amendment is page 3, line 14 through page 4, line 16.
Senator Abler to the divided amendment, the first part.
Well, thank you. Divided government, divided amendment. Maybe there's some, never mind, Mr. President. So this is a small little taste of program integrity. There's some bigger bills moving. We've been working on this for a good long time. This is, I think, the consensus of the consensus, just to make sure that something gets out. As I remarked, we have 11 days left. So I'll just go through the 4 sections. The first section is section 1, curiously enough, and it requires when the report is made about how funds are being expended, they'll also report on the unannounced site visits that providers are getting, which you know is a pretty hot topic. Section 4 and Section 5 are, so I got that right? Section 4 merely says that abuse does not include billing errors. And Mr. President, you know how that can be. And when you're making a mistake, you're not doing fraud. That was quite agreeable to our group. And then Sections 5 and 6 merely replace a state definition with a federal one about fraud. So that's the amendment, and I hope people can vote for it. Thank you.
Senator Hoffman to the A48 first half as divided.
It's a friendly amendment.
Further discussion on the divided first half of the A48 amendment. All those in favor say aye. Aye. Opposed? A48 as divided is adopted. Senator Abler.
Mr. President, I forgot to vote. Can we vote again? Thank you. And so the second part has to do with an in-camera review, which is something that's going to be discussed in judiciary. But this gives individuals who have been, an ALJ would actually look over their case and then see if it's what it's like. So, but Mr. President, I'll withdraw that, and I appreciate the body's attention to these two matters.
Senator Abler withdraws the second half of the divided A48 amendment. Further amendments on the bill. Senator Rasmussen.
Thank you, Mr. President. I would like to offer the A51.
Senator Rasmussen offers the A51 amendment. The Secretary will report the amendment.
Senator Rasmussen moves to amend Senate File Number 4476 as follows. Page 8, after line 6, insert. This is the A51 amendment.
Senator Rasmussen.
Thank you, Mr. President. This would add in language from Senate File 4390, which is a bipartisan bill that has passed both through the Human Services Committee and the Commerce Committee that would authorize short-term home health and nursing care insurance for Minnesotans. More than 40 states have this as an option for Minnesotans, and this would allow the Department of Commerce and the Department of Human Services to offer these plans to Minnesotans so that they can have more coverage if they need short-term home health or nursing care coverage.
Senator Hoffman.
Thank you, Mr. President. It's a good amendment. Vote green.
Further discussion on the A51 Rasmussen amendment. All those in favor say aye. Aye. Opposed? A51 is adopted. Further discussion or amendments? Senator Rasmussen.
Thank you, Mr. President. I'd like to offer the A43 amendment.
Senator Rasmussen offers the A43 amendment. The Secretary will report the amendment.
Senator Rasmussen moves to amend Senate File Number 4476 as follows. Page 56, after line 30, insert. This is the A43 amendment.
Senator Rasmussen.
Thank you, Mr. President. One of the concerns that I hear from across the state is how both nursing home cuts in last year's budget and regulatory burdens that have been passed in previous sessions and are being proposed in this session will cause nursing homes and assisted living facilities to close across the state. So the language in the A43 amendment would match some other voluntary receivership language that we have in the bill, and it would allow assisted living facilities and nursing homes facing serious financial strain because of the requirements in this bill to be able to turn over their facilities to a voluntary receivership to the regulator so that those residents in the facility can continue to receive those services. There's already a provision in this bill on continuity of care, and I think this would line up well with that.
Senator Hoffman to the A43 amendment.
Thank you, Mr. President. If we're going to have receivership, it's just complex. It's worth the conversation. I don't think we can have it on the floor because this would put our bill out of balance if indeed that the financial, I'm looking at some assumptions here. If MDH is supposed to take receivership, unless there's already an existing pot of money that they can do that from. But I would tell folks to vote no on this.
Senator Westlin.
Mr. President, I request a roll call.
Roll call is granted. Further discussion on the amendment. Seeing none, the Secretary will take the roll on the A43 amendment. Senator Herr for those voting remotely.
Mr. President, Senator Carlson votes no.
Senator Carlson votes no.
Senator Port votes no.
Senator Port votes no.
Senator France votes no.
Senator France votes no.
Senator Murphy votes no.
Senator Murphy votes no.
Senator Marty votes no.
Senator Marty votes no.
Senator Wickman votes no.
Senator Wicklund votes no.
Senator Champion votes no.
Senator Champion votes no.
Senator Latz votes no.
Senator Latz votes no.
Senator Fateh votes no.
Senator Fateh votes no.
Senator Rest votes no.
Senator Rest votes no.
Senator Putnam votes no.
Senator Putnam votes no.
Senator Dibble votes no.
Senator Dibble votes no.
Senator Hemmingsen Yeager votes no.
Senator Hemmingsen Yeager votes no. Senator Jasinski.
Thank you, Mr. President. Senator Barr votes aye.
Senator Barr votes aye.
Senator Liskey votes aye.
Senator Liskey votes aye.
Senator Nelson votes aye.
Senator Nelson votes aye.
And thank you, Mr. President. Senator Pratt votes aye.
Senator Pratt votes aye.
Thank you, Mr. President. Senator Lang votes aye.
Senator Lang votes aye. All senators having voted who desire to vote, the Secretary will close the roll. There being 33 aye votes and 34 nay votes, the A43 amendment is not adopted. Senator Rasmussen.
Thank you, Mr. President. The Minnesota Constitution requires the governor on appointments of key officers to seek the advice and consent of the Minnesota Senate. It provides an important oversight role for this body. And we see whether it was our nation's founding fathers putting that in the United States Constitution or our state's founders putting it in our state constitution, it is a unique role that this body, that us as members have to provide a check on the executive branch. Minnesota needs the Senate to act as a check on the executive branch right now. We are facing an unprecedented fraud crisis that has been enabled by a lack of leadership at the Department of Human Services. They've allowed billions of hard-earned tax dollars to go to criminals. When they've had evidence and tips on kickbacks, they refuse to investigate and refer for prosecution. We have the legislative auditor found that multiple manager-level employees fabricated documents, backdating documents, saying that they were doing program integrity work when in fact they were not. And then when we have had leadership come to testify in front of Senate committees, they refuse to acknowledge that Minnesota has a fraud problem. And unfortunately, Mr. President, we've seen Senate Democrats also refuse to hold the Walz administration to account for their failures on fraud. If we look back when we had a leadership transition within the Department of Human Services, we had a temporary commissioner for more than a year which created a situation where this body wasn't able to provide advice and consent. And then when we did finally get a formal confirmation for a permanent commissioner at the Department of Human Services, Senate Democrats didn't schedule a confirmation hearing for weeks. And then once we finally got to the eve of the confirmation hearing, Governor Walz announced a reshuffle where he asked the deputy commissioner to become the commissioner, and then had the new commissioner ask the former commissioner to become the deputy commissioner. But then the new commissioner is going to be out on leave, so the old commissioner, who's now the deputy commissioner, will now be effectively acting as the acting commissioner. Mr. President, if a Republican governor would have done that, Democrats would have scheduled a no kings rally. It is using the law to get around this Senate's advice and consent. And when that announcement came out, Mr. President, Senate Democrats didn't stand up for this body. They didn't stand up for Minnesotans and say that we have an important oversight responsibility. And again, we have a lack of accountability over the state, I would argue, the state's most important agency that has an annual budget of $25 billion, has thousands of employees, and we are seeing the consequences of a failure in leadership at that agency. So to help address that, Mr. President, I would like to offer the A47.
Senator Rasmussen offers the A47 amendment. The Secretary will report the amendment.
Senator Rasmussen moves to amend Senate File Number 4476 as follows. Page 87, after line 25, insert. This is the A47 amendment.
Senator Rasmussen.
Thank you, Mr. President. This amendment would get at this problem of accountability that we have seen within the Department of Human Services and the lack of a confirmation process. It would clearly state that we would have a salary limit for unconfirmed agency heads, and that limit would be set at 75% of the salary rate prescribed in law until the Minnesota Senate affirmatively confirms those agency heads. This would, I think, have brought forward a confirmation hearing and vote much quicker than what we have seen play out over the last year plus, given this leadership reshuffle. I would ask for member support and request a roll call.
Roll call is granted. Senator Hoffman.
Thank you, Mr. President. We must be in a different committee today because what he's bringing forward is not germane. It's if you look under 35.1, you go to it 35.2, this relates to a different matter altogether. It's not our jurisdiction to do what the good senator from Fergus Falls is saying. It is not germane. I'd ask you to rule it out of germaneness.
Senator Hoffman raises a point of order under Senate Rule 35.2. Advice. Senator Rasmussen.
Advice, Mr. President. If you look at the title of the bill, this is a bill for an act relating to state government. And it's all about human services, all about the Department of Human Services. And I thought, Mr. President, that we were going to have a confirmation hearing this week where the Senate would have the opportunity to do our constitutional mandate, to provide advice and consent. And because we were denied that opportunity as a body, this is our opportunity to say that we are not going to allow the administrative branch to go unchecked, that we are going to recognize our constitutional responsibilities and hold agency leadership to account. And so I'd ask you to find the point of order not well taken.
The point of order is well taken.
Mr. President, I appeal the ruling of the President and request a roll call.
Senator Rasmussen appeals the ruling of the President, and a roll call is granted. The Secretary will take the roll on the appeal of the President. A green vote sustains the decision of the President. A red vote overturns it. Senator Herr.
Mr. President, Senator Carlson votes aye.
Senator Carlson votes aye.
Senator Port votes aye.
Senator Port votes aye.
Senator Frantz votes aye.
Senator Frantz votes aye.
Senator Murphy votes aye.
Senator Murphy votes aye.
Senator Marty votes aye.
Senator Marty votes aye.
Senator Wickland votes aye.
Senator Wickland votes aye.
Senator Champion votes aye.
Senator Champion votes aye.
Senator Latz votes aye.
Senator Latz votes aye.
Senator Fateh votes aye.
Senator Fateh votes aye.
Senator Rest votes aye.
Senator Rest votes aye.
Senator Putnam votes aye.
Senator Putnam votes aye.
Senator Hauschild votes aye.
Senator Hauschild votes aye.
Senator Dibble votes aye.
Senator Dibble votes aye.
Senator Herman Singh Yeager votes aye.
Senator Hemmingson Yeager votes aye.
Thank you, Mr. President.
Senator Jasinski.
Thank you, Mr. President. Senator Barr votes no.
Senator Barr votes no.
Senator Lang votes no.
Senator Lang votes no.
Senator Liskey votes no.
Senator Liskey votes no.
Senator Miller votes no.
Senator Miller votes no.
Senator Nelson votes no.
Senator Nelson votes no.
Senator Pratt votes no.
Senator Pratt votes no.
Thank you, Mr. President. Senator Weber votes no.
Senator Weber votes no. All senators having voted with the desire to vote, there being 30, the secretary will close the roll. There being 34 aye votes and 33 nay votes, the decision of the president is upheld. Further discussion or amendments to the bill? Senator Gruenhagen.
Well, thank you, Mr. President. Yeah, I have the A49 amendment.
Senator Gruenhagen offers the A49 amendment. The secretary will report the amendment.
Senator Gruenhagen moves to amend Senate File Number 4476 as follows. Page 87, after line 25, insert. This is the A49 amendment.
Senator Gruenhagen.
Well, thank you, Mr. President. Yeah, you know, Senator Rasmussen talked about some of the fraud problems that we have at DHS, okay? And this amendment attempts to address that in a single way. You know, recently Channel 5, just the other day, reported that one of the employees at DHS for several years was reporting fraud, and instead of being listened to, she was told, just disregard this or don't worry about it. Well, she continued to report her concern about fraud, and then one day she was walked out of DHS and fired. So we've heard from numerous whistleblowers that they were persecuted or threatened if they continue to be concerned about fraud. So secondly, we just had the Trump administration under Dr. Oz freeze another $91 million of federal funds. I and others have said time and again, we need to cooperate with the feds in relationship to fraud because we need that money to help the people who really are hurting. That's what we need to do. So members, I think it's time, if we look at the facts, that the management of DHS is held accountable. So what my amendment does, it basically says that if the Center for Medicare Services confirms that there is 2% fraud, if this is 2% fraud is confirmed, the commissioner of DHS would be terminated without any opportunity for other employment in the state of Minnesota. So I hope that Senator Hoffman would see this as a friendly amendment, but I'll let him comment.
Senator Hoffman.
Mr. President, I really want to take this amendment, good senator from Glencoe, but after conferring with a bunch of, this is not within our jurisdiction, and so it's the wrong committee. But I really like where he's going with this, but I cannot accept it. I sent you the note, Glenn, so thank you.
Senator Kupek.
Thank you, Mr. President. I would request a roll call.
Roll call granted. Senator Gruenhagen.
Yeah, I was going to request a roll call. But members, I would just say this. Let's send a message to DHS to confront the fraud as soon as they're being alerted. I mean, we had an OLA report. DHS said, well, we couldn't do anything about the fraud. The Office of Legislative Auditor said, yes, the laws are in place, you could have done something. So it's one denial after the next. And members, this is creating chaos among the people that we all want to help, our disability, all the different areas of Medicaid. And I've even heard allegations that people have died from this. And instead of pointing at the Trump administration because they're freezing funds because they're concerned about fraud, we need to look at the four fingers pointed back at the state of Minnesota. There's people in my district that think that Governor Walz and Keith Ellison are a criminal cartel, that they're in on this deal of fraud, and that we're actually using state and federal tax dollars to buy votes. Somebody should go to jail. The least we should do is when we have this, and we're talking billions of dollars of fraud. This amendment, I think, is generous that says it takes their annual budget times 2%, which would be a little over $200 million of fraud that's actually identified. But members, when somebody is going to be terminated, it gets their attention, especially those in leadership. This is unconscionable what we have allowed to happen. And members, let's vote green and send a message to DHS. Cooperate with the federal government. Stop hurting Minnesota citizens that need help. And let's nip this fraud in the bud rather than fire people who are reporting the fraud, our first line of defense, the employees at DHS. Please vote green. Thank you, Mr. President.
Senator McEwen. Nope. Pass on Senator McEwen. Further discussion on the amendment. Secretary will take the roll on the A49. Senator Herr.
Mr. President, Senator Carlson votes no.
Senator Carlson votes no.
Senator Port votes no.
Senator Port votes no.
Senator France votes no.
Senator France votes no.
Senator Murphy votes no.
Senator Murphy votes no.
Senator Marty votes no.
Senator Marty votes no.
Senator Wickland votes no.
Senator Wickland votes no.
Senator Champion votes no.
Senator Champion votes no.
Senator Latz votes no.
Senator Latz votes no.
Senator Fateh votes no.
Senator Fateh votes no.
Senator Rest votes no.
Senator Rest votes no.
Senator Putnam votes no.
Senator Putnam votes no.
Senator Hauschild votes no.
Senator Hauschild votes no.
Senator Dibble votes no.
Senator Dibble votes no.
Senator Hemmingson Yeager votes no.
Senator Hemmingson Yeager votes no. Senator Jasinski.
Thank you, Mr. President. Senator Barr votes aye.
Senator Barr votes aye.
Senator Lang votes aye.
Senator Lang votes aye.
Senator Liskey votes aye.
Senator Liskey votes aye.
Senator Miller votes aye.
Senator Miller votes aye.
Senator Nelson votes aye.
Senator Nelson votes aye.
Senator Pratt votes aye.
Senator Pratt votes aye.
Senator Weber votes aye.
Senator Weber votes aye. All senators. All senators having voted with the desire to vote, the secretary will close the roll. There being 33 aye votes and 34 nay votes, the A49 is not adopted. Further amendments on the bill. Secretary will give the bill its third reading.
Senate File Number 4476, a bill for an act relating to state government, modifying provisions relating to human services, continuity of care, aging, and disability services, etc.
Third reading. Further discussion on the bill as amended. Senator Abler.
Well, thank you, Mr. President. All we read in the paper about is how no one's getting along and the other body can't decide almost what day it is. I just want to commend Senator Hoffman for running a committee that is none of that, that is all about inclusion, collaboration, cooperation, and focus on the most important elements of this arena, which is more than 100,000 people who have some great challenges in their life. Some can not get out of bed but by help. Some will not make it through the day without assistance. Others just need some other assistance to get through their work. And he has been just so committed in his passion for the individuals that we serve that it shows and it bleeds through in this bill. And even looking at how some of the amendments went, some contention, some working together, that's just how it's supposed to be. And so I do want to caution him, however, that the $130 or so million that he gets to spend here may not end up as the final number. It's just a possible thing. But I do want to, there's some things that we absolutely have to do in this bill, as in the Health and Human Services bill, the compliance with the federal stuff. Whatever you think of it, we have to comply. And without that, the department will be in a great world of hurt. And speaking of the department, I would like to give a shout out to the people who are working there from top to bottom. It's been a rocky time for them for all kinds of reasons, and in nearly, I'll say, every case through no fault of their own. Though they get out of bed, they're every day committed to trying to make a very complex system work, now navigating between a very interesting world in Washington and an interesting world here, affected greatly by politics in both the state and the feds. And yet they get out of bed and they come and they do their work. And I have the highest regard for every member of that team, Mr. President. And so part of why that is that this compliance part will make their job possible. And if you knew the hours they kept, Mr. President, you would think that maybe you're back in your internship. So they are just that good of people. And I wanted to single out a couple other things that I hope we can do at the end. Senator Hoffman, with his creative math, was able to reduce some unfinished business from the last session. There's $178 million of reductions looming because we couldn't quite find all the savings last time. But it's still a far cry better than the $460 million shifts to the counties that was originally proposed. And so that $178 million in this bill is reduced to $113. I hope that when the dust settles, that can be evaporated so that the service providers in the counties won't have to experience any more cost. Senator Liskey, if he were here, would talk about the family residential services. This bill takes a great step toward trying to keep those intact. Those individuals who are serving, I want to just publicly thank them for what they do. They have cared for some of these these individuals with great challenges, and sometimes for decades, and they've given them a really quality life by embracing them and their family. And finally, Mr. President, a waiver reimagined in this bill is put on, well, it's actually abolished. And it was well intended, but it's not worked at all the way that we hoped. anybody. And so this is put on indefinite hold forever with the money that Senator Hoffman was able to find. I hope when the dust settles, we'll be able to either remedy this to an extreme sense or let it just expire on its own. So, members, there are a few things in this bill some people may not like, and I understand that, but I intend to support it. And as I said before, we have 11 days. What's in this bill will change the lives of people, even with the limited money that's available. And I know this body is united in that, and whether people vote yes or no, I understand why they might vote no because of some of the nursing home concerns, and I share those. That does not mean they don't care about the individuals, and I think as a Senate, Mr. President, all 67 of us wake up every morning caring to serve the people who are represented by this group, which Mr. President, when I addressed the rally, I said, hello, people. And these are people just like anybody else. So thank you, Mr. President.
Senator Gruenhagen.
Oh, I just want to thank Senator Hoffman for running a committee that had good, robust discussion and on issues, and I just want to compliment him on his approach there, other than the yelling at me about using the word illegal immigrant. Okay. Anyway, but I do rise about this concern over and above what I had stated earlier as far as the fraud and the consequences to the commissioner and how they've treated employees who tried to report it. According to the analysis here I have from our Senate research, we're adding in the next 3 years 244 FTEs. Now, that might be reduced with Senator Frenz's amendment. I'm not sure how that would play out. But the initial bill had a 244 increase in FTEs. Members, we really have to get a handle onto continuing to add FTEs to the state government. I think we have somewhere in the neighborhood of over 40,000 state employees here at the state of Minnesota. And maybe every one of them is necessary, okay? But we just keep adding and adding and adding. Now, in the private sector, I had a friend. He was retired, but what his profession was, and he worked with a lot of large private companies across the country, he did work-study programs. In other words, their firm was hired to come in and especially where there was a merger, and analyze each employee in terms of their responsibility, the amount of work that they need to do, and to evaluate if, when, and how much the employee was necessary or could be consolidated. Now, government resists that. Government doesn't seem to want accountability in that area. So one of the things that makes me want to vote against this bill is just this constant drumbeat of adding FTEs, adding FTEs, adding FTEs, with no analysis. There's no analysis as to the necessity and whether or not what they're doing is really necessary. I'm all about proper staffing to meet the needs of the most vulnerable. But on the other hand, we've heard about the nursing homes and how we're short in those areas, up to 50,000. And I can't imagine that we need to keep piling on more and more FTEs at the state without any type of analysis. So members, think about that. We need, as a legislature, to get a handle on the number of employees that are working at the state. We want them to be effective and efficient and not just continue to pile on, taking money away from nursing homes, assisted living, schools, local schools, versus just bloating the state government. So with that, members, I'm going to have to vote red. Thank you.
Senator May Quaid.
Thank you, Mr. President. I'm very excited to vote green on this bill. I've brought it up numerous times today on the floor, but I'll just say it again. I have constituents who live in an assisted living facility called the Rosemount. one of the residents has actually lived in Rosemount longer than I've been alive, and I think shortly after the city was incorporated. Her and her husband were just on the cover of our local newspaper. She was a teacher at the school, her daughter still lives in the community, and they were so excited to move from their house directly across the street into the Rosemount. When they moved in, they were paying $4,300 a month. November, they were paying $4,300 or $2,800 a month, excuse me, in November. Today they are paying $4,300 a month. Breaking up our family. My rent has gone up by $1,600. No one will pick up my mother if she falls, but if I pay $350 extra, someone will knock on her door every day to see if she's fallen. Our food budget has been cut in half. Morale and harm is real. I was paying $7,400 a month for my mom. Now I'm paying $11,000 a month for my mom. Thank goodness she's not going to live much longer because we couldn't afford it. These are the stories from my constituents. In no world should it be legal for a for-profit entity to take over an assisted living facility and jack the rent up 40% in a month. That's unconscionable. In no world should it be legal for a for-profit entity to take over a nonprofit assisted living facility and cut the food budget in half and still raise prices. Mr. President, we've seen things for falling, fees for falling, $150 to $250. A getting glasses from the side table fee, $18 per instance. An activities reminder fee. An opening and closing a heavy door fee. An excessive emails fee. Using Blue Cross Blue Shield plan fee. A paying by check fee. What is happening to Minnesota seniors is unconscionable. And you want to talk about stealing money out of their pockets. We are watching corporations and LLCs and for-profit entities and individual family trusts organize themselves in a corporate shell game to suck up the money from our seniors and their families, a lot of which is Medicaid dollars. And somehow that's just called good business. But in this bill, we recognize that it is fraud, and it is wrong, and it should be illegal. I'm so grateful that in this bill we are prohibiting self-dealing. Although it was tried to be stripped out, it survived. We're going to prohibit self-dealing. We're going to make sure that if assisted living facilities are going to raise the rent or issue ridiculous fees, that there's a reason for that raise above inflation, or there's a reason for that fee. We're going to understand the corporate structure when for-profit entities take over. What's happening to my constituents should not be happening, Mr. President, because this language that we're going to pass off the floor today was present in a conference committee report last year. I fought tooth and nail to keep it in, but at the end of the day, special interests got in the way, and it came out. This year, it has to stay in. Last year, I fought tooth and nail, and they were just hypothetical stories to me. This year, they're my constituents. Now, I know I can be punchy sometimes, Mr. President, but I think most people know that I am very, very kind until you get on my wrong side. And one of the fastest ways to get on my wrong side is to be a for-profit entity ripping off seniors who happen to be my constituents. This language is some of the most important work we will do as legislators. I'm so proud to have done it. I'm so grateful it is in this bill. I thank Senator Hoffman and the members of the committee, because I will not go away until my constituents are protected. Thank you, Mr. President.
Senator Rasmussen.
Thank you, Mr. President. I appreciate the opportunity to get to serve on the Senate Human Services Committee. And one of the things that I enjoy about serving on the Senate Human Services Committee is that you don't really know what's going to happen most of the time. Oftentimes when we come to the floor, when we're in other committees, we know how the vote and the debate is going to occur. We know what the end result will be before we get there. And I have to credit the leadership of Senator Hoffman and also Senator Abler and the other members of our committee to coming at this work with an open mind. And we have disagreements. We have areas where we're able to come together. But I view the conversations that happen in that committee as good faith and trying to understand the issues and serve Minnesotans as best we can. Mr. President, members, there are some good provisions in this bill that are the result of that collaborative bipartisan work. And I'm glad to see here on the Senate floor today that Senate Republicans were united in stopping these unworkable staffing mandates that even Commissioner Jody Harpstead recognized would not serve the interests of families and patients. I'm disappointed that we weren't able to provide tax relief to Minnesota seniors who are in nursing homes. And many of them, unfortunately, without that change, will get priced into poverty, given the rates that are being charged to them. But Mr. President, members, I think the biggest deficiency I've seen so far out of our work, with 11 days left to go, is that the Minnesota Senate hasn't taken up major program integrity and anti-fraud measures this session. It's the biggest issue that I hear about from my constituents. They're outraged that billions of their hard-earned tax dollars are going to criminals instead of the Minnesotans who need these services. And they're demanding action, they're demanding accountability. And when we had the opportunity to insert just a little bit of accountability today, to assert the Senate's role to provide advice and consent over key appointments to key agencies like the Department of Human Services, unfortunately, we saw the Senate Democrats turn down those opportunities. And so my concern, Mr. President, is that we have seen the Health and Human Services budget bill come and go. Now we're seeing the Human Services bill go, and we only have 11 days left to stop fraud here in our state and hold those who are responsible for the fraud to account. And we'll continue to work on these issues in good faith with anyone who wants to address fraud, but we haven't done enough to date. Thank you, Mr. President.
Senator Fateh.
Thank you, Mr. President. I want to make a clarification to what was just said right now. We've been working jointly as the Human Services Committee and the Health and Human Services Committee to work on a program integrity package that will be heard in Finance on Friday. It's been a joint effort by both sides of the aisle, led by Chairs Westlin and Hoffman, but also Senator Abler and myself. And so there has been really good work that has been ongoing around program integrity this past session that hopefully will conclude very soon. So thank you, Mr. President.
Final comments from the author, Senator Hoffman.
Mr. President, thank you. As much joy it is to be in this chamber and talk about the things important to us, I smiled because Senator Champion came over and was telling me that Jimmy Jam and Terry Lewis are playing at the State Fair this year. And it just lit me up because the joy it is to be hearing the Minneapolis sound is the same as the joy it would be if I would have had a nomination for a Grammy maybe in 1994 or 2001. But really, Senator Abler's remarks really set the tone about the committee. Senator Rasmussen, thank you for your remarks as well. We do have many agreements. We have many disagreements. But here's the thing we don't do, Mr. President. We don't personalize that. Senator Gruenhagen, I really wanted to take your amendment. But after I said no to Senator Rasmussen, right, you talk about you never know which way we're going here in our Human Services Committee. I sat back and I said, well, I got to be consistent here. And Senator Limmer said, why be consistent anymore, Hoffman? You know, I mean, it was kind of like that piece of it. But that's really what goes on. There's no personalization in our work, Mr. President. And we couldn't do the work without the people that are involved. Aaron McQuaid, Senator Rasmussen, Senator Wickland, Senator McEwen, since I forgot to say her name the first time we did our policy bill, Senator Fateh, Senator Abler, Senator Mohammed, Senator Gruenhagen, and of course our fiscal watchdog, Senator Utke. It's a joy being in committee with you. It really is. Want to remember our committee staff, Liam Monahan, who's probably the smartest person in the state of Minnesota when it comes to how statutes line up. And if you don't believe me, just watch some of our hearings. Kyle Raymond, I'm so glad the state of Washington lost you to the state of Minnesota, because it's a joy having you with your fiscal wonkiness. Of course, my legislative assistant, Olivia Hitchcock Willis, who came into this year not doing this, right? And it's great because she really jumped in a pond and was able to row that boat the way it should be done. And Sam Parmaker, a committee administrator, wow, you jumped in, Sam. You really not only understood human services, but you also understood the process of things that need to do. And of course, that wouldn't have been helpful without our friend Emily Spateri, who is our researcher. And Bryce Hengst, I forgot to mention you in the policy piece, and I told you I was going to mention you in the budget piece, but I'm going to say it twice. Thank you and thank you. You absolutely are a great partner with Sam, and you have been with our committee administrator, David Zach, who is visiting us in the chamber today. He's actually in the gallery. But how you two work, how everybody works together, you do what our committee has done. You set the ego aside and you actually work on what's important in front of us. And we have disagreements. And we have lots of agreements, but we get our work done. I also want to, Mr. President, the drafting support staff need to be thanked. Steve Carver, Tyler Gustafson, Hannah France, Greg Cotto, Daniel Nelson, Allison Kent, and Kiara Hone. Thank you for supporting Liam and Kyle and the other staff that are there. And of course, Elise Bailey at the department and Christy Grum at the department. It takes a team, folks. It's about us. It's the collective. And what we do matters. Because, you know, there's a gavel on my wall in my office that was given to me by a good friend of mine whose father said, "We all do better. When we all do better, vote green, Mr. President."
The Secretary will take the roll on final passage of Senate File 4476 as amended. Members, please vote speedily. Senator Bolden.
Thank you, Mr. President. Senator Carlson votes aye.
Senator Carlson votes aye.
Senator Port votes aye.
Senator Port votes aye.
Senator Marty votes aye.
Senator Marty votes aye.
Senator Wicklund votes aye.
Senator Wicklund votes aye.
Senator Rest votes aye.
Senator Rest votes aye.
Senator Putnam votes aye.
Senator Putnam votes aye.
Senator Hochschild votes aye.
Senator Hochschild votes aye.
Senator Hemmingson Yeager votes aye.
Senator Hemmingson Yeager votes aye.
And Senator Herr votes aye.
Senator Herr votes aye. Senator Jasinski.
Thank you, Mr. President. Senator Barr votes no.
Senator Barr votes no.
Senator Liskey votes no.
Senator Liskey votes no.
Senator Lang votes no.
Senator Lang votes no.
Senator Miller votes no.
Senator Miller votes no.
Senator Nelson votes no.
Senator Nelson votes no.
Senator Pratt votes no.
Senator Pratt votes no.
And thank you, Mr. President. Senator Weber votes no.
Senator Weber votes no. All senators having voted with the desire to vote, the Secretary will close the roll. There being 35 aye votes and 32 nay votes, the bill is passed and its title agreed to.
Members, we'll now go to Senate file number 2373. Senator McEwen.
Thank you very much, Mr. President, members. Senate File 2373 contains Department of Labor and Industry policy and fiscally neutral budget recommendations, which are primarily related to phasing out Class A and Class B electrical installers licenses, to technical and clarifying changes to electrical codes, and technical clarification to local government enforcement of the state building code. The bill would also establish an exemption from the Fair Labor Standards Act for minor league baseball players compensated pursuant to a collective bargaining agreement. And I'll just quickly go through each section in case people wanted to follow along. Section 1 is, as I just referred to, contains the exemption from the Fair Labor Standards Act for minor league baseball players who are compensated pursuant to a collective bargaining agreement. And language from Senate Section 2 makes those technical and clarifying modifications to the authorization for DLI to enter into agreements with municipalities for the local government to enforce the state building code within their jurisdiction. Sections 3 and 5 would remove references to the Class A electrical installer license from Minnesota's electrical code. Class A electrical installer licenses have not been issued since December 1st, 2007. Sections 4 and sections 6 through 9 are additional proposals from the Department of Labor and Industry, which would eliminate the issuance of new Class B electrical installer licenses on December 1st, 2027. Existing license holders would be able to renew and continue operating under that licensure. In addition, it would lower a threshold where a flat $165 electrical inspection fee applies to projects for addition, alteration, or repair of dwellings. It would lower the threshold where a flat fee applies for projects that include 15 or more electrical circuits to 14, because the existing $3 per circuit fee under current law would lead a 14-circuit project to cost more than a project with 15 or more circuits. There are additional conforming changes to the building code as well. And with that, Mr. Chair, this is a small bill, but a good one, and I stand for questions and ask for member support. Thank you.
Members, any discussion on Senate file number 2373? Any amendments? Any discussion? Seeing none, the Secretary will give the bill its third reading.
Senate file number 2373, a bill for an act relating to labor and industry, exempting minor league baseball players from a minimum wage and overtime requirements.
Third reading. Any discussion before we vote for final passage of Senate file number 2373? Senator Pappas.
Thank you, Mr. President. I just wanted to mention that the minor league baseball section of the bill is supported by both minor league baseball players and management, and we had support letters from Major League Baseball Players Association and the Major League Baseball, as well as from the St. Paul Saints, and appreciate your support for the bill.
Any other discussion before we vote? Anything from the author, or would you like us just to vote? Senator McEwen.
Just very briefly, Mr. President, I just want to thank all of the members of the committee as well as our staff. We always have good discussion and I hope a good time in our committee in getting some good quality work done. So thank you, everybody.
The Secretary will take the roll for final passage of Senate file number 2373. Members, please vote. Senator Bowden, for those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Carlson votes aye.
Senator Carlson votes aye.
Senator Port votes aye.
Senator Port votes aye.
Senator Marty votes aye.
Senator Marty votes aye.
Senator Latz votes aye.
Senator Latz votes aye.
Senator Rest votes aye.
Senator Rest votes aye.
Senator Putnam votes aye.
Senator Putnam votes aye.
Senator Hochschild votes aye.
Senator Hochschild votes aye.
Senator Hemmingson Yeager votes aye.
Senator Hemmingson Yeager votes aye.
Senator Herr votes aye.
Senator Herr votes aye.
Senator Marty votes aye. Senator Murphy votes aye.
Senator Murphy votes aye.
And Senator Hoffman votes aye.
And Senator Hoffman votes aye. Senator Jasinski, for those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Barr votes no.
Senator Barr votes no.
Senator Liskey votes no.
Senator Liskey votes no.
Senator Lang votes aye.
Senator Lang votes aye.
Senator Miller votes aye.
Senator Miller votes aye.
Senator Nelson votes aye.
Senator Nelson votes aye.
Senator Pratt votes aye.
Senator Pratt votes aye.
Senator Weber votes no.
Senator Weber votes no.
Senator Duckworth votes no.
Senator Duckworth votes no.
1 second, Mr. President.
Senator Jasinski, for those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Johnson votes aye.
Senator Johnson votes aye. All members having voted who desires a vote, the Secretary will close the roll. There being 48 ayes and 18 noes, the bill is passed and its title agreed to. Members, we now go to House File Number 3709. Senator Seeberger.
Thank you, Mr. President. It is my pleasure to speak today in support of House File 3709, which at its core allows banks and credit unions to offer custodial accounts for digital assets, essentially a modern safe deposit box for digital assets such as cryptocurrencies. This legislation ensures that Minnesota-based financial institutions can continue to serve their customers and members as financial services evolve, rather than forcing Minnesotans to turn to unregulated, out-of-state, or even offshore providers for services that are already being used today. In my district, as in all of yours, banks and credit unions play a vital role in the financial lives of our constituents. They are trusted, relationship-based institutions that know their customers and are accountable to their communities. As digital assets and virtual currencies become more mainstream, customers are asking reasonable and familiar questions. Can my local financial institution help me safeguard these assets? Can I work with someone I know and trust? Can this be done under Minnesota law and regulatory oversight? This bill answers these questions in a responsible way. As digital assets and virtual currencies continue to enter the mainstream, we are seeing the need for consumer protection and our financial institutions to be able to adapt to meet these needs. Put simply, the financial world is changing. Digital assets and virtual currencies are no longer a niche interest. They are already being used to invest, transact, and store value. As this shift happens, Minnesotans are already engaging with these technologies. This bill does not push financial institutions into speculative activity. Instead, it allows banks and credit unions, if they choose, to offer custody and safekeeping services under rigorous financial security and integrity standards overseen by both state and federal regulators. The standards for digital assets mirror those that already apply to other assets held in custody by credit unions and banks. Institutions must maintain written policies addressing risk management, cybersecurity, internal controls, and business continuity. And they must notify the Department of Commerce before offering these services. This framework and protection matters to Minnesotans, and it helps ensure that innovation happens here under Minnesota's regulatory supervision rather than outside of it. Without the ability to provide custodial accounts, credit unions are seeing assets leave, with customers seeking crypto exchanges elsewhere. One Minnesota credit union saw $1 million leave for crypto exchanges just 3 years ago. Last year, that number rose to 15 million. This is just one financial institution in one community, and it's happening all across Minnesota. This bill helps level the playing field. Without this authority, large national firms or non-bank entities will dominate this space, while local institutions, despite being more trusted by consumers, are left on the sidelines. This bill ensures that Minnesota consumers can continue to rely on the same community-based institutions they already trust for mortgages, small business lending, and financial guidance. This bill is about consumer choice, protection, and competitiveness. It allows Minnesota financial institutions to respond to changing customer expectations while preserving the safety, transparency, and accountability Minnesotans expect. For the communities I represent, and for the many Minnesotans who want innovation without sacrificing trust, this bill strikes the right balance, and I respectfully ask for your support. And, Mr. President, I would request a roll call.
Roll call requested, roll call granted. But a roll call is usually appropriate already for, it happens automatically for final passage. Senator Rasmussen.
Thank you, Mr. President. I will offer the A1 amendment.
Senator Rasmussen offers the A1 amendment. The Secretary will report the A1 amendment.
Senator Rasmussen moves to amend House File Number 3709 as follows. Page 1, line 16, delete fiduciary or. This is the A1 amendment.
Senator Rasmussen, to your A1 amendment.
Thank you, Mr. President. The A1 amendment is identical to an amendment that I offered on the Commerce Policy Omnibus Bill that was voted on and adopted during that debate. It would simply clarify that the credit unions would be offering this service in a custodial capacity, and we would be removing mentions to offering this as a fiduciary capacity, just to make sure that we have clear definitions in the bill. I have talked with this amendment with the bill author and also with the Minnesota Credit Union Association.
Senator Seeberger to the A1 amendment.
Thank you, Mr. President. I view this as a friendly amendment.
All in favor of adoption of the A1 amendment, say aye. All those opposed, say no. The motion prevails and the A1 is adopted. Any additional or other amendments? Senator Jaskowski.
Thank you, Mr. President. Would the author yield for a question?
Senator Seeberger, will you yield? She will yield. Senator Jaskowski.
Thank you, Mr. President. Thank you, Senator Seeberger. Senator Seeberger, can people in Minnesota, or can credit unions and banks in Minnesota engage in this activity now without this regulation? That's my question.
Senator Seeberger to the question.
Thank you, Mr. President. Thank you, Senator Drazkowski. There's a question in the minds of banks and credit unions whether it is a permissible practice, and this bill would clarify that they can, and provides the terms and the frameworks and the safeguards for them to be able to do it.
Senator Jaskowski.
That's the end of my question. Thank you, Mr. President.
Any additional questions or amendments? Senator Lucero.
Thank you, Mr. President. No amendments, so I probably could have waited until third reading, but...
Can I do that? Can I go to third reading?
Sounds great.
Any other amendments? Seeing none, the Secretary will give the bill its third reading.
House File Number 3709, a bill for an act relating to financial institutions allowing certain virtual currency custody services to be offered and performed.
Third reading, Senator Lucero. Thank you so much.
Thank you, Mr. President, and I'm wondering if the chief author would yield for a question.
Senator, will you yield? She will yield. Senator Lucero.
Thank you, Mr. President. Thank you, Senator Seeberger. I'm in favor of the concept. I just want to make sure that I have clarity in understanding what it is that's being done here. To help give that clarity, could you provide an example of maybe a competitor, a service, a company that's providing this service now in the digital realm, to help wrap our minds around what's happening now, maybe with a company that we're familiar with or people are familiar with, and how this then would be the equivalent of that existing service that's being offered?
Senator Seeberger to the question.
Thank you, Mr. President. I'm pausing because I am blanking on the name of various digital currency crypto organizations. There are several out there. The difference being this: they are generally unregulated. They are generally outside of the relationship that's provided by your local bank or credit union. They are generally without a central location for someone to go ask a question. And they're not always as consumer friendly as your local bank or credit union. And this bill provides both the familiarity, the name recognition, the local source, and some additional guardrails that are not provided by other crypto institutions.
Senator Lucero.
Thank you, Mr. President. And if she would yield for another question.
Senator Seeberger will yield for another question. She will yield. Senator Lucero.
Thank you, Mr. President. And thank you, Senator Seeberger. It wasn't my intent to catch off guard. So here are some of the apps that I have on my phone, which are wallets that would be used to store crypto for those who decide to purchase or engage in transactions. So Uphold would be an example. Robinhood, Crypto.com, and Coinbase. Those are several apps that are wallets, but they also facilitate in the transactions. So the question, Mr. President, Senator Seeberger, are these the type of existing services that now with this legislation we're seeking to allow our local banks to engage in identical or similar services as some of those apps that I just referenced.
Senator Seeberger.
Thank you, Mr. President. Thank you, Senator Lucero. Yes, it was Coinbase that I was trying to search my brain for. But yes, you refreshed my recollection. It is. So think of like a safety deposit box for crypto. Yes. And a consumer is free to use Coinbase or any of the other ones that you described, or to use their local bank or credit union for this service. And the advantage of using their local bank or credit union is just a few extra little guardrails and protections, and of course that community trust that's involved.
Senator Lucero.
Thank you, Mr. President, and I appreciate that clarification, Senator Seeberger. And if she would yield for just one more question.
Senator Seeberger, will you yield for another question? She will. Senator Lucero.
Thank you, Mr. President. Thank you, Senator Seeberger. I'm looking at the bottom of page 1, so lines 1.18 through 1.21. It's talking about, or it's titled Safety and Soundness. And it says a banking institution that engages in virtual currency custody services must conduct the activity in a safe and sound manner. It must maintain written policies and procedures governing risk and management, internal controls, cybersecurity, business continuity, and compliance. Those are incredibly generic or very high-level terms. So the question I would have, Mr. President and Senator Seeberger, in my experience in the cybersecurity industry, obviously banking has its own series of regulatory and governance mandates, which would be much more specific and rigorous. Can you confirm that this language doesn't impugn or override, or it falls within more strict regulatory compliance mandates currently in place on the banking industry?
Senator Seeberger, to the question.
Thank you, Mr. President. Thank you, Senator Lucero. Local financial institutions may hold digital assets and custodial accounts under the same safety and soundness standards they already follow when safeguarding other member and customer assets, using established controls for risk management, cybersecurity, and internal oversight. The authority granted by this bill is narrowly limited to custody and administration, meaning institutions may not invest, trade, lend, or otherwise put member digital assets at risk through speculative activity. And the Department of Commerce, in its regulatory oversight role, retains full power to limit or condition these services only if they are conducted in an unsafe or unsound manner, ensuring strong supervision without singling out digital assets solely because of the technology involved.
Senator Lucero.
Thank you, Mr. President, and thank you again, Senator Seeberger. I'm in favor of this. I encourage people to vote green on this. And this will be among a series of bills in multiple industries we are going to continue to see in this body as technology continues to evolve and as people continue to adopt these various forms of technology and or assets, digital currency, and use them in everyday transactions and commerce. So thank you, Mr. President. Again, vote green.
Any other discussion? Senator Dibble. Oh, I saw you standing. Any other discussion? Anything else, Senator Seeberger? We can go vote if you don't have anything else to say. Okay, we will go vote. The Secretary will take the roll for final passage as amended to House File 3709. Members, please vote so we can move expeditiously. Senator Bowden, for those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Port votes aye.
Senator Port votes aye.
Senator Carlson votes aye.
Senator Carlson votes aye.
Senator Marty votes aye.
Senator Marty votes aye.
Senator Rest votes aye.
Senator Rest votes aye.
Senator Putnam votes aye.
Senator Putnam votes aye.
Senator Hochschild votes aye.
Senator Hochschild votes aye.
Senator Hemmingson-Yager votes aye.
Senator Hemmingson-Yager votes aye.
Senator Herr votes aye.
Senator Herr votes aye.
Senator Murphy votes aye.
Senator Murphy votes aye.
Senator Hoffman votes aye.
Senator Hoffman votes aye.
Senator McEwen votes aye.
Senator McEwen votes aye.
And Senator Latz votes aye.
And Senator Latz votes aye. Senator Jasinski, for those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Barr votes no.
Senator Barr votes no.
Senator Liskey votes yes.
Senator Liskey votes aye.
Senator Nelson votes aye.
She's already voted.
Whoops, sorry. Senator Pratt votes aye.
Senator Pratt votes aye.
Senator Weber's on the floor. Senator Duckworth votes aye.
Senator Duckworth votes aye.
And we're waiting on one.
Senator Jasinski, for those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Lang votes aye.
Senator Lang votes aye.
Senator Johnson votes aye.
And Senator Johnson votes aye. All senators having voted who desires to vote, the Secretary will close the roll. There being 51 ayes and 16 nays, the bill is passed and its title agreed to. Members, we will now go to House File 4063, Senator Johnson-Stewart.
Thank you, Mr. President. I move that the amendment made to House File number 4063 by the Committee on Rules and Administration in the report adopted May 5th, 2026, pursuant to Rule 45, be stricken.
Members, Senator Johnson-Stewart moves that the amendment made to House File 4063 by the Committee on Rules and Administration in the report adopted May 5th, 2026, pursuant to Rule 45, be stricken. All in favor of that motion, say aye.
Aye.
All those opposed, say no. The motion prevails. All right, to the bill.
Thank you, Mr. President. This House File 46, I just dropped it. House File 4063 is the school bus safety package. This was brought to us by the DPS, and it provides for some additional school bus safety provisions that we already voted on earlier in this session. It makes some specific changes to school bus laws, including clarifying training authorizations, updating first aid kit requirements, and ensuring that a US DOT number is required for all school buses. Specifically, it allows for behind-the-wheel training in school buses on private roads. It requires all school buses to have a US DOT number, which is really important for school bus inspections and to accommodate school buses moving between state or across state lines. And then lastly, it just requires best practices for first aid kits in school buses. Senators, I ask for a green vote on this bill. Thank you, Mr. President.
And Senator Johnson-Stewart, I should have asked you this earlier before we adopted the motion, because I usually ask people to explain, or senators to explain the difference between the Senate bill and the House bill only. So just tell me what are the differences there.
Thank you, Mr. President. I believe the difference is that, if you remember, on March 27th, we voted to change change statute around vehicles approaching a school buses and the stop arm. Since that was already passed on the Senate floor, the House file amended that portion of the bill out so that we don't have duplicative statute. Thank you for the reminder.
All right. Any other discussions or amendments before we give the bill its third reading? Seeing none, third reading.
House File Number 4063, a bill for an act relating to transportation modifying first aid kit requirements on school buses.
Third reading. Any other discussion before final passage? Seeing none, the Secretary will take the roll for final passage of House File 4063. Senator Bowden, for those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Carlson votes aye.
Senator Carlson votes aye.
Senator Port votes aye.
Senator Port votes aye.
Senator Marty votes aye.
Senator Marty votes aye.
Senator Rest votes aye.
Senator Rest votes aye.
Senator Putnam votes aye.
Senator Putnam votes aye.
Senator Hochschild votes aye.
Senator Hochschild votes aye.
Senator Herr votes aye.
Senator Herr votes aye.
Senator Murphy votes aye.
Senator Murphy votes aye.
Senator Hoffman votes aye.
Senator Hoffman votes aye.
Senator McEwen votes aye.
Senator McEwen votes aye.
And Senator Latz votes aye.
And Senator Latz votes aye. Senator Jasinski, for those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Barr votes aye.
Senator Barr votes aye.
Senator Lang votes aye.
Senator Lang votes aye.
Senator Liskey votes aye.
Senator Liskey votes aye.
Senator Pratt votes aye.
Senator Pratt votes aye.
And thank you, Mr. President. Senator Duckworth votes aye.
And Senator Duckworth votes aye.
Mr. President, I missed one. Senator Johnson votes aye.
And Senator Johnson votes aye. All senators having voted who desires to vote, the Secretary will close the roll. There have been 63 ayes and 3 nays. The bill is passed and its title agreed to. Members will now go to House File 4151. Senator Limmer.
Thank you, Mr. President. House File 4151 amends the private detective and productive agent licensing statute by striking references to partnerships so that a partnership may no longer be licensed under statute. The bill further clarifies that if a corporation is the applicant for a license, the corporate chief executive officer, the chief financial officer, the qualifying representative, Minnesota manager, if it exists, also be registered and must meet all of the licensing requirements. In addition to that, fingerprints must be taken and submitted to the FBI for a criminal history check. The bill is before us, and it has the unanimous support of the licensing board, and I ask for your support.
Any other discussion on House File 4151? Seeing none, the Secretary will give the bill its third reading.
House File Number 4151, a bill for an act relating to occupations modifying eligibility of certain applicants for license to serve as private detectives or protective agents.
Third reading. Any other comments by anyone? Senator Limmer, any final comments? Seeing none, the Secretary will give the bill, the Secretary will take the final vote. for final passage of House File 4151. Senator Bowden, for those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Port votes aye.
Senator Port votes aye.
Senator Marty votes aye.
Senator Marty votes aye.
Senator Rest votes aye.
Senator Rest votes aye.
Senator Putnam votes aye.
Senator Putnam votes aye.
Senator Housechild votes aye.
Senator Housechild votes aye.
Senator Herr votes aye.
Senator Herr votes aye.
Senator Murphy votes aye.
Who did you say?
Senator Murphy votes aye.
Senator Murphy votes aye.
Senator Hoffman votes aye.
Senator Hoffman votes aye.
Senator McEwen votes aye.
Senator McEwen votes aye.
Senator Latz votes aye.
Senator Latz votes aye.
And Senator Carlson votes aye.
And Senator Carlson votes aye. Senator Jasinski.
Thank you, Mr. President. Senator Barr votes aye.
Senator Barr votes aye.
Senator Duckworth votes aye.
Senator Duckworth votes aye.
Senator Johnson votes aye.
Senator Johnson votes aye.
Senator Lang votes aye.
Senator Lang votes aye.
Senator Liskey votes aye.
Senator Liskey votes aye.
And thank you, Mr. President. Senator Pratt votes aye.
And Senator
Pratt.
Senator Pratt votes aye. All senators having voted who desires to vote, the secretary will close the roll. There being 66 ayes and 0 nays, the bill is passed and its title agreed to. Members, we'll go to House File 3769, Senator Westlin.
Thank you, Mr. President and members. I believe I am the last thing standing between you and a social event this evening. I do have before us the Department of Corrections technical fix bill. It truly is a simple and technical bill. It does include in Section 1, adds the treatment of juveniles under the substance use disorder treatment programs. Under Section 2, it previously said the department was to operate at one adult correctional facility, a mental health unit. Now it says in at least one facility, and it now permits the transfer of an individual for assessment, evaluation, or stabilization in addition to short-term care. Those are the primary parts of the technical corrections. In fact, I think those are all of them. It's a good bill. Vote green.
Any other discussion on House File 3769 before we give the bill its third reading? Seeing none, the secretary will give the bill its third reading.
House File number 3769, relating to corrections, clarifying in law the multiple levels of substance abuse care provided by the Commissioner of Corrections.
Third reading. Any other discussion before we move to final passage? Seeing none, the secretary will take the roll for final passage of House File 3769. Senator Bowden, for those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Port votes aye.
Senator Port votes aye.
Senator Marty votes aye.
Senator Marty votes aye.
Senator Rest votes aye.
Senator Rest votes aye.
Senator Putnam votes aye.
Senator Putnam votes aye.
Senator Hochschild votes aye.
Senator Hochschild votes aye.
Senator Hur votes aye.
Senator Hurd votes aye.
Senator Murphy votes aye.
Senator Murphy votes aye.
Senator Hoffman votes aye.
Senator Hoffman votes aye.
Senator McEwen votes aye.
Senator McEwen votes aye.
Senator Latz votes aye.
Senator Latz votes aye.
Senator Fateh votes aye.
Senator Fateh votes aye.
And Senator Carlson votes aye.
And Senator Carlson votes aye. Senator Jasinski.
Thank you, Mr. President. Senator Barr votes no.
Senator Barr votes no.
Senator Duckworth votes aye.
Senator Duckworth votes aye.
Senator Johnson votes aye.
Senator Johnson votes aye.
Senator Lang votes aye.
Senator Lang votes aye.
Senator Liskey votes no.
Senator Liskey votes no.
Senator Pratt votes aye.
Senator Pratt votes aye.
Thank you, Mr. President.
All members having voted who desires to vote, the Secretary will close the roll. There have been 57 ayes and 9 nays. The bill is passed and its title agreed to. Senator Dibble. Senator Johnson-Stewart.
Thank you, Mr. President. Having voted on the prevailing side, I move that the vote whereby House File 4063 was passed by the Senate on May 6, 2026, be now reconsidered.
Any discussion to that motion? All in favor say aye. All those opposed say no. The motion prevails. Now the bill is back before us for reconsideration. Senator Johnson-Stewart, anyone? Any final words? Senator Farnsworth.
Mr. President, as long as we're here, I'm wondering if the chief author would yield to a question.
Senator Johnson-Stewart, will you yield? She will yield. Senator Farnsworth.
Thank you, Mr. President. And I thought I'd missed my opportunity for this, but I'm just wondering, this is such a technical bill. Is there an engineer in the room that could explain this bill to us?
Senator Farnsworth, don't get her started, please. Any other discussion? Seeing none, the Secretary will take the roll for final passage of House File 4063. So all the remote people, reporters, you have to do your work all over again. Senator Bowden, for those voting pursuant to Rule 40.7.
Thank you, Mr. President. Senator Carlson votes aye.
Senator Carlson votes aye.
Senator Port votes aye.
Senator Port votes aye.
Senator Marty votes aye.
Senator Marty votes aye.
Senator Putnam votes aye.
Senator Putnam votes aye.
Senator Hochschild votes aye.
Senator Hochschild votes aye.
Senator Hur votes aye.
Senator Hurd votes aye.
Senator Murphy votes aye.
Senator Murphy votes aye.
Senator Hoffman votes aye.
Senator Hoffman votes aye.
Senator McEwen votes aye.
Senator McEwen votes aye.
Senator Latz votes aye.
Senator Latz votes aye.
And Senator Fateh votes aye.
And Senator Fateh votes aye. Senator Jasinski. Senator Jasinski, for those voting pursuant to Rule 40.7.
Thank you, Mr. President. Our members all vote the same. Just kidding. Senator Barr votes aye.
Senator Barr votes aye.
Senator Duckworth votes aye.
Senator Duckworth votes aye.
Senator Johnson votes aye.
Senator Johnson votes aye.
Senator Lang votes aye.
Senator Lang votes aye.
Senator Liskey votes aye.
Senator Liskey votes aye.
Senator Pratt votes aye.
Senator Pratt votes aye.
And thank you, Mr. President. Senator Wiesenberg votes aye.
And Senator Wiesenberg votes aye. All members having voted who desires to vote, the Secretary will close the roll. There have been 64 ayes and 3 nays. The bill is passed again, and its title agreed to. Again. All right, members, we will now move to the 13th order of business. That is announcements of Senate interest. Senator Jasinski.
Thank you, Mr. President. I know I've said this before. I'll say it again tonight. As the I-90 Highway 14 party, special thanks to Greater Mankato Growth, who've taken on and sponsored this event, as well as Green Seam, Minnesota Pork Producers, Hormel, Minnesota Cable, Farm Bureau, St. Paul Saints, many that are doing this. 5 o'clock tonight at CHA Stadium. It's a great venue. This is for members. This is for staff. This is for nonpartisan. This is for everyone to come and enjoy this evening, get together, have some great food. Thanks to all the sponsors. Senator Frentz, I'm going to turn it to you.
Senator Friends.
Thank you, Mr. President. Thank you, Senator Jasinski. Members, I hope you can stop by the I-90 party. We do a lot of work here. It's a good thing to celebrate. Greater Mankato Growth is our local chamber, and they host it, but would welcome anybody from all 4 corners of the state. Plus, I happen to know, if you don't go to the I-90 party, Senator Jasinski is going to bring it up to you every day for the rest of your life. Thank you, Mr. President.
Senator Nelson.
Thank you, Mr. President, members. I just want to add my invitation to the I-90 party. It is the place to be. I also want to thank the Rochester Chamber of Commerce also for supporting as well. I-90 is that east-west connection that connects our state and the commerce with it. So look forward to seeing you there.
Any other announcements of Senate interest? Senator Young.
Thank you, Mr. President. Members, tomorrow, May 7th, Thursday, the Senate Minnesota Asian Pacific Caucus invites you to stop by. We will Senator Paz, Senator Herr, and myself will be providing food for all Senate members in the Senate room tomorrow at 11 a.m. And for Senate staff, both Democrats and Republicans will get food over at the MSB 2308, and we bring this in celebration of the Minnesota API month celebration. And so we're bringing banh mi and spring rolls and some spices for the ancient Scandinavian tradition here in Minnesota. Thank you.
Senator Westrom.
Mr. President, just announcement of Senate interest. Today, several of us had the opportunity to take our first ride in a self-driving autonomous vehicle around the Capitol and the streets of St. Paul. It went very well, uneventful, which is what it was supposed to be, but great technology, members, that we continue to look at advancing in our state safely, as we've worked on this for several years, but we're at the next stage where we can drive and ride in these vehicles, and I just wanted to make that awareness to members as we need to look at further legislation to advance this in our state for constituents as an option. It's intriguing, and the ride went very well today for those of us that got the chance and opportunity.
Members, without objection, the following senators will be excused from today's session. Senator Limmer from 3:45 to 4 o'clock p.m. Any other announcements of Senate interest? Seeing none, who's doing the motion? Senator Bowden.
Thank you, Mr. President. I move that the Senate do now adjourn until Thursday, May 7th at 11 a.m.
On that motion, all in favor say aye. All those opposed say no. The motion prevails. The Senate is now adjourned.